Colleagues, we are running late. Shall we please start? But before we do that, I'd just like to verify that those who are joining us virtually are all there. Shall we do roll call, please, colleagues on the virtual platform? Just announce
Good morning,
yourselves.
Deputy Chief Justice.
Morning,
Good morning,
Mr.
it's Commissioner Singh here. Good morning, good to see you.
Morning, Deputy Chief Justice.
Is that Mr. Bernard?
That's correct.
Oh, good morning. Are you well, sir?
I'm well, yourself?
I'm fine, thanks. Who else is out there?
Good morning, everybody.
Good morning, Ms. Breitenberg. How are you? I'm asking after your health, Commissioner Breitenberg. Are you well?
I'm fine, thank you. How are you?
I'm fine too.
That's wonderful. That's wonderful.
Good. Is Premier Mabuyane with us?
Good morning, DCJ. Good morning
morning,
to all
Premier.
members of JSC. Thank you very much. I'm here on the call.
Thank you. Good to have you with us.
Thank you. Thank you.
All right. Please bring the candidate in. Okay.
I hope that's Magwati, DCJ. Is that Magwati?
He's talking about Makwati. I think there's a tender there.
Oh, what? What about Makoti?
I hope that's Magwati, the one that we are about to drink. From my side, I can't hear DCJ. I can't hear the sound.
Oh, I'm sorry, my mic was not on. I was asking if Makoti was still operational, and DM Jeffrey assures me it is. I hope it's as profitable as it was when I was a little girl.
We're trying to get it back there. Very hard, working very hard on it.
Yeah, you really should. It's a shame what happened there, if I may say so. But this is, it's unfortunately, it's not Makoti, it's 5 Roses. So, what can I say?
Hard luck.
Thank you so much. Good morning, Ms. Spence.
Good morning.
How are you?
I think I have the requisite amount of nerves for the occasion,
That's good.
but I'm very, very privileged to be here, so thank you. How are you?
I'm fine, thanks. Nerves are good. They keep you on your toes.
Thank you.
You were born in the very city where you wish to be appointed.
That's correct.
That's good. You did pupillage in 2010 in Gqeberha.
I did.
And, well, after graduating with an LLB from what is known as Nelson Mandela University today.
That's correct.
But before you did LLB, you studied science and were quite good at it by all accounts.
Thank you. Yes, I did.
You did a BSc and majored in microbiology and zoology, then did honors in zoology and wrote a thesis in ecotoxicology, and then made this dramatic switch
I did.
and pivoted to law. That's quite unusual. May I ask what brought that on?
Yes, certainly. During my honours year, we had to give various presentations, and one of the presentations which I gave had to do with the differences between the economic impact, the environmental impacts between pebble bed reactors and normal power plants. And when I approached the topic, I did it through the lens of the law, and I looked at different judicial decisions from around the world, and really that ignited my passion for the legal profession, and that was when I decided to make the change.
Wow. All right. Can you just tell us some pupils, women pupils,
Yes, I have. I've been very privileged to be able to do that.
and did a magnificent job with that, as it seems.
Thank you so much.
So you've been with the Eastern Cape Society of Advocates since.
Yes, I have.
All right. You have acted in the High Court.
I have. As we sit here today, I'm presently in my 42nd week of acting.
In which seats particularly?
Sorry?
Where exactly? Where have you acted?
I
In Port Elizabeth?
am, my post is at the Gqeberha High Court. However, what happens in the Eastern Cape is that we rotate between the different seats of the court. So I've also done duty in Mthatha and Bishu and Makanda.
What kind of cases have you done? I imagine you'd have done a first spread on criminal and commercial work as well.
Yes, I've done the full spread of cases that come to the Eastern Cape bench. So I've sat in criminal matters, I've sat in civil trials, opposed applications, urgent applications, unopposed applications, a bail appeal, and I've written various criminal review judgments.
Have you sat on appeals proper?
I have sat on appeals. I've done 2 weeks of appeals.
All right. Full benches?
Yes, I have.
Okay. I meant full court?
Yes, certainly.
Yeah, okay. Have you had an opportunity to write judgments during your acting stint?
Yes, I have had an opportunity to write judgments. I have delivered 40 written judgments to date.
That's commendable. Any managed to get in the law reports?
Yes, I have. I have 4 reported judgments at present.
All right, I'll stop there for now and hand over to the rest of the commissioners.
Thank you.
No one has indicated. Oh, my goodness, I'm sorry I've not done this in a few months. I forgot that I have to give first dibs to the head of court, who is represented by Judge Bloom. Judge Bloom, do you have questions for the candidate?
Sorry, I do.
Just bring the mic close to you, please.
Thank you. You've touched on the judgments that you have written, if I am correct, 40 in all.
Yes.
Can we just break them down? I have made some notes. 17 opposed applications,
That's correct, Judge Bloom.
10 civil trials,
That's correct.
then criminal trials, you've had 3 of those.
I've had 2 criminal trials, but written 3 criminal judgments. The one criminal trial was a multiple murder trial, The second was an alleged rape of a minor. The third judgment is the sentencing in respect of the murder trial.
And then criminal reviews, you've had 5 of those?
That's correct.
And one appeal judgment.
That's correct.
You have made mention when the Deputy Chief Justice asked you about reported judgments. I have made a note of 4 of those,
That's correct.
and 2 of them have been referred to with approval in Lawson.
That's indeed so.
Yes. Then can we just deal with comments? You might not know this, but the Judge President in the Eastern Cape has requested judges to comment on your nomination, and I am informed that not a single judge made negative comments about you. To the contrary, the Deputy Judge President in Gqeberha has sent me to the Judge President, a letter, and with your permission...
Deputy Chief Justice, we are struggling to hear.
Can you just try to speak directly to the mic?
Thank
Judge
you.
Blom?
Am I audible now?
We can hear you, but when you look at the candidate, then you speak away from the mic.
Sorry, thank you. The Deputy Judge President in the Eastern Cape, in Gqeberha, has sent comments, and I'm not going to read everything, but just a few things. Colleagues who have interacted, he says, with her, and referring to you, have commented very positively on her abilities as a judge, her work ethic, her integrity, her positive outlook, and what is clearly evident, her love for the law and her work. I'm not going to ask you to comment on it, but feel free to do so.
Thank you.
She has an impressive work ethic, and there was earlier this year an occasion, sadly so, when one member of the judiciary in the Eastern Cape fell ill, and you had to get into your car and travel to that division.
That's correct,
You
sir.
want to share that experience with us, please?
Yes, certainly. It was actually a wonderful experience. I had spent a week in Johannesburg on the aspirant judges training course, and it was on the last day that the JP informed me that one of the members of the bench had fallen ill at the Mthatha High Court, and would I make myself available to go through there on the Sunday and to do the motion court duty role. And for anybody who knows, the motion court duty role in Mthatha is certainly a formidable force. There are many, many files. On the unopposed role, it is not uncommon for there to be 100 unopposed applications and 8 opposed applications in that week, which you need to field along with many urgent applications that come your way. So I arrived back in Gqeberha on the Friday night and got in my car on the Sunday morning to drive through to Mthatha to prepare those files and take up those duties.
Then, can we just proceed? 1 or 2 more excerpts from the letter. She has, in my view, all the attributes to make an excellent judge, and he concludes by saying, I have no reason to doubt that her integrity and her moral ethical standards are above reproach, and that she will serve the Constitution and the task of the judiciary well. I have accordingly no hesitation to recommend the appointment of Advocate Bands to the vacant position. You want to comment to that?
Thank you. I'm very, very humbled by those comments. Thank you very much.
Then can we just deal with the report submitted by Nadell?
Certainly.
You have appeared in both the Constitutional Court and in the Supreme Court of Appeal, and from the documentation, you appeared as a junior with Advocate, Mr. Bielefeld SC.
Correct.
Now, there are questions about you not having appeared yourself on behalf of your clients, and you were led by a silk. I have had occasion yesterday to speak to Mr. Bielefeld about that. I'd like you to share with us who drafted those heads in both courts
I drafted the heads of argument in both courts.
and what was his contribution towards those heads of argument.
It's a difficult question to answer. I don't want to say anything negative, but the heads of argument which I drafted were unchanged. They were accepted as they were.
Yes. And why did you not appear yourself?
I did not appear by myself because I was invited to be Advocate Bielefeld's junior. He asked me to come on board to assist him in those matters. Those were not matters that I had originally been briefed in.
Thank you. Just one last aspect. Can we just deal with the position in Gqeberha? At the moment, we have 2 female judges and we have 5 male judges in Gqeberha.
That's correct.
And when we talk of racial composition, we have 2 white males,
That's correct.
and the rest of the complement are black in the sense of Xhosa and colored.
That's correct, Judge Blom.
We have lost, over the last 2 years in the Eastern Cape, through retirement, Judges Skuman and Revelas, and elevation to the Supreme Court of Appeal, Judge Goosen. How do you think your appointment will assist with diversity on the bench of the Eastern Cape?
Thank you, Judge Blom. What the Constitution provides is that there is a need that the bench in a division, broadly speaking, is representative of the gender and the racial composition of the community in which it serves. And as pointed out by Judge Blom, there are currently no white females serving on the bench, and accordingly, that would certainly be in line with transformation. So I certainly feel that my appointment would be welcome, one, from a racial perspective, and 2, also on a gender perspective.
Deputy Chief Justice, those are my questions. Thank you.
Thank you very much, Judge Blom. Premier, do you have questions for the candidate?
Thank you very much, DCJ. No, not really. Judge Bloom has almost covered me. I was more interested on the question on demographics. I think advocate has attended to that. So far, thank you very much, DCJ.
All right. Okay. AP Beza?
Thank you, DCJ. Good morning, Advocate Pence.
Good morning.
Supposing you were presiding in a civil trial concerning a delictual claim, what would be the test applicable to establish negligence, as was restated in Kruger versus Coetzee?
Certainly, thank you. And I'm going to paraphrase. I'm not going to say it exactly as stated in Kruger versus Coetzee, but what the court to determine negligence will need to determine is whether a reasonable man would reasonably foresee the harm that's complained of, whether his conduct would cause that harm, and whether he took reasonable steps to guard against such an occurrence.
Thank you.
Thank you.
And my second and last question to you. You are sitting in an appeal against sentence. The basis for the appeal being that the sentence is excessive. What is the test or approach to an appeal against sentence, as was, for example, restated in many cases? The one that comes to mind even State versus Malchus.
Sorry, I've drawn a blank there in a moment. If you're looking at sentencing and you're looking at it from an appeal perspective, for example, if a minimum sentence is applicable in the circumstances, one needs to revisit whether there were substantial and compelling circumstances to deviate from the minimum sentence applicable. So one needs to look at the discretion which the court had at the time and the factors which the court considered.
And as a general rule, where the minimum sentences legislation finds no application, what would be their approach?
Was the exercise of the discretion judicial in the circumstances? So was there a material misdirection of the court quo?
Thank you. I'll leave it at that.
Commissioner Singh?
Thank you very much, DCJ, and good morning once again. Good morning, Advocate Bands.
Good morning.
I'm on the virtual platform. Yeah, I see that in addition to what Judge Blom said about letters that came through, Nadel required one of us to raise the issue that you do not seem to belong to a member of any legal association. Not that I personally think that it matters, but can you just take us through? You received a nomination from Advocates for Transformation, but there's nothing listed as a member of any legal organization. Do you want to just tell us about that, please, first? Thank you.
Certainly. Thank you for the opportunity to address that question. How I've always viewed memberships of legal associations or any other association is that when you become a member, it's not merely to have the association behind your name. You need to have the time to be able to meaningfully engage with the society and the objects of the society. And if you do not have that, then you ought not to become a member. So when we're looking at what's close to my heart, one of those aspects, and I'm sure we'll get to that topic later, is transformation. So instead of joining AFT, what I felt I could do was I could make a difference at the rock face. So what was the impact that I could make on a bar level for transformation? And that's where I focused my energy. I have in the interim, however, been approached by Saula at the end of last year, and they asked me if I would be interested in joining the association, to which I gave them an answer in the affirmative. I do have an interest in joining the association, and certainly now that this is the third term which I've acted for consecutive terms, and it certainly lends itself more to a more structured environment to be able to contribute more meaningfully to an organization. So that it is certainly something that I will take up.
Okay, just as a follow-up, can you tell us how much of energy you've devoted to the transformation cause in whatever platform that was available to you?
Yes.
I noticed a letter here from Ms. Zishtala, and I was hoping that you would want to take her up to the position, mentor her up to the position that you are in now, appearing before the JSC. So can you speak to those aspects, please?
Yes,
Thank you.
absolutely, and she would certainly be every bit capable of taking up that position in due course. So I think, let me answer the question in two parts. First, what does transformation mean to me? And then two, what have I done for transformation? So people often talk to me about this topic because it is close to my heart, and the only way that I can explain what transformation means to me is to bring in Ubuntu. I am because we are, and that is how I've always viewed our life. So transformation isn't just what people think. It's not about briefing patterns. It's not about just getting somebody's foot in the door. It's about fostering relationships. It's about bringing it home, and then it spills over into the workplace and into the legal community. It's about an open door policy. It's about providing mentoring, opportunities, introductions to attorneys, and just taking a considered interest in the life of the person who you are hoping to enhance in whatever way you can, whether that be financially or by virtue of the time that you are able to give to that. So what have I done for transformation? you would have noted from the documents that I submitted together with the questionnaire, there were 2 letters of support that were written by 2 young females who are now practicing attorneys in Gqeberha. One is Nwabisa and the other one is Lily. Now, Nwabisa I met at the age of 10 years old, and she showed promise in the academic sector. So I took her under my wing. My then husband at the time, we put her into a better school to provide her with a better education. We paid for her studies, her books, her extra learning so that she was able to understand English, because her English, she wasn't very fluent at the time. She then showed an interest in tertiary education, which she was so very capable of, and she went on to study an LLB. I invited her to come and work for me as a legal secretary. The reason for that was twofold. One, she could be at the face of practice and she could get the necessary experience and see what it was like to be in practice. And 2, it enabled her to build relationships with attorneys and other advocates, which would afford her a stepping stone into the profession. I'm not sure if I need to go into with Naledi, but similarly, it was, Naledi and I met each other at the gym, and at the time she was working for Red Bull, and she indicated to me that she was very interested in a career in law. And I said to her at the time, she was a first-year student, that Nwabisa was about to move on. She had just been accepted for articles, and I encouraged her to come and work for me, again, as a legal secretary, for the same reasons that I encouraged Nwabisa to do so. And I'm proud to say she went on to do law school and her articles, and she's currently serving pupillage at the Gqeberha Bar. Apart from that, because that's not the only contribution that I've made, I have an open door policy at all times for everybody who needs to come or wants to see me. I avail myself for lecturing, for checking young advocates' work, introductions, passing down briefs, because at the end of the day, what we need is a sustainable practice. If we're truly going to transform the legal profession, it's not sufficient to sit on a pupillage committee and, for example, take 6 young black women if you don't give them the tools to have a sustainable practice in due course. That's the only way that will transform the profession.
Thank you, Advocate Benz, and
Thank
thank
you.
you, Deputy Chief Justice.
Thank you, Commissioner Singh. JP Mlambo.
Thank you very much, DCJ. Good morning, Advocate Benz.
Good morning, JP.
You mentioned that you've acted in opposed motions as well.
Yes.
I've got a 2-pronged question. One is, do you agree with me that the opposed motions, which also have what we call special opposed motions, that is the complex and lengthy ones, that's where judges mostly accumulate reserved judgments?
Correct.
What was your average turnaround time in terms of hearing an opposed matter and handing down the judgment, on average?
On average, I would say about 2 months.
About 2 months. Good. And do I have a follow-up, DCJ? The rule is just 2 questions. It's a bit constraining, but anyway. You also confirmed that you've said in full court appeals. Am I correct?
Yes, that's correct.
That's where you were considering a judge's judgment.
Yes.
Did you have occasion to write any of those appeal judgments?
I've written appeal judgments, but not for the full appeal court, no. Not for sitting as 3 judges.
Okay. My last question, that's my second question. Those were follow-ups. It's a different question. You are a single parent, you have a 9-year-old or 10-year-old child.
That's correct.
You're coming to the bench. Are you fully aware what you're going into from an income perspective?
Yes, certainly I'm fully aware.
Then you are prepared to take the consequences.
I am. Thank you, JP.
Thank you,
Coming
DCJ.
to I think if I may just answer that question a little bit more in depth. I haven't availed myself for this position for financial considerations. It is a deep calling of service, and that is why I'm here. And on that basis, I'm more than satisfied for the financial implications which taking up a position has.
Thank you, Advocate Benz. Thank you, DCJ.
Thank you, Deputy Chief Justice. Good morning, Advocate Vance.
Good morning, Commissioner.
Okay, you spoke a lot about transformation, and I commend you for that.
Thank you.
But what I want to know, there's very few women who are appointed silk.
Sorry, I couldn't hear that.
There are very few female practitioners who get silk status. Silk status?
Yes.
Do you think the criteria that we are using now to recommend people for silk, is it sufficient or there's something wrong? Because as long as we don't get enough females to take up silk, we are not transforming.
Yes, I can only speak from a perspective of the Gqeberha Bar, and certainly we've within the recent years, had 2 females who have taken up silk, and no other female has really availed themselves for that position as of yet. So, unfortunately, I can't really speak to that.
Thank you. I'm fine.
Thank you, Commissioner. Commissioner Ndwaitu?
Thank you, Deputy Chief Justice. Good morning, Advocate Burns.
Good morning.
You were asked earlier questions about the common law in delict and the sort of common law approach to application of sentence on the criminal side. I want to ask you also legal questions, but from a customary point of view. If you had a case where there is a contested rule about custom, what approach would you follow and what are the leading cases?
Unfortunately, I haven't had an occasion to consider that, and unfortunately, I'm unable to answer that when it comes to customary law.
Yes. The reason I ask this is not to trap you, but you are going to the Eastern Cape, which is a primarily rural province, and the overwhelming majority of people there are under the rule of customary law. And there is an overwhelming number of cases that are before the courts where customary law is sought to be applied. And I am always worried that judges are very ignorant when it comes to customary law. And customary law has become the ugly stepsister of the common law, which is a violation of the Constitution on its own, because Section 39(2) expressly says customary law is part of South African law. So whenever I see a judge who just says, well, I know nothing about customary law, I get a bit worried. Are you going to take any steps to educate yourself about customary law?
Yes, I absolutely will, and thank you for that. I think the starting point is always going to be the facts of the case that you're presented with, and so I'll deal with the matter that I'm presented with as I do with any other matter that comes before me. I'll have a consideration of the papers. I will look at whatever the legal principles are that are involved in the matter, and I will make sure that I am fully researched on the topic before I enter a court so that I can engage meaningfully on the issues in dispute between the parties as well as the applicable legal principles, and I will do that.
Yes, and the leading cases you may want to start with are Bear, Alexco, Maelane, Gongose. Should I go on, Deputy Chief Justice?
Thank you. My pen isn't working, but I'll be sure to watch the recording. Thank you very much.
Let's not risk overkill, Commissioner.
Thank you very much, DCJ. Good morning, Judge.
Good morning.
I want to ask you about something that has triggered my mind, and I'm not really sure what the correct answer is, and I'm hoping that you will be able to assist me. There is a case that you said with the then Deputy Judge President Van Zyl. It is Vabasa versus Master of the Eastern Cape High Court. You remember that matter?
I do remember the matter.
Yes. I'm not going to ask you about the general facts of it. I'm just interested in the approach. And when I read the judgment, it really triggered this question to me. When somebody applies to review the decision taken by the Master of the High Court to appoint an executor or an executrix, what is the right process that that person should use? Is the person supposed to review in terms of perjury? and comply with the requirements of PAJA, or should the person actually review in terms of the Administration of Deceased Estates Act, because it does provide a section for review, Section 95.
Yes.
Because I was quite interested in your judgment. You deal with the section, then immediately after the section, you go to PAJA.
Yes, correct.
And when you go to PAJA, you don't even deal with Rule 53 of the Uniform Rules of Court. So I'm just trying to understand what is the procedure that litigants should use. Should they review that decision through PAJA and then use Rule 53, or can they rely on the review procedure provided by the Act itself? What is the right procedure? Because it seems like here you kind of like club them together, which is quite worrying for me. I just want to understand what is the right procedure.
Yes, thank you. I'm not sure if you have a page number for that case. I just wanted to once again have regard to Section 95.
Page
I know that I deal with.
Page 125. And I'm more interested in paragraph 39
Thank you. That's the paragraph I'm looking for.
and 40 and 41 of your judgment. That's where my question really is based.
Yes, I'm just trying to find where I specifically quote Section 95. I'm not sure where I have it now, but how I...
It's paragraph 39.
No, I'm unfortunately not finding it, but how I see the legislation and how I rationalize it in my mind at the time was this. Was that Section 95 provides that the decisions are reviewable. So that's the starting point. The decision is reviewable. What is the procedure that we're going to use for that review, and what further rules are applicable to that? And I saw that as then a review within the context of PAJA, and then the rules of court would come into play. So I don't see it as the section in the Act providing for a self-standing review on its own in isolation to the remainder of the applicable law.
Okay, I guess this is my question. As a litigant, when I draft my papers, do I have to rely on PAJA and comply with this procedural requirements that are put on PAJA? Because what PAJA does, also you have to rely on certain provisions to indicate as to where the actual issue is. Or can I rely directly on this review procedure and say, I'm allowed to review in terms of this particular legislation? I'm not really sure what the correct answer is. I just want to get your view on it.
Yes, I really wish I could find Section 95 in my judgment. It would really assist in me explaining my view on the topic. But I see it as a PAJA review, and I'm not sure if that's answering your question. I certainly see it as a PAJA review.
No, it's fine. I'll leave it there.
Thank
Thank you
you.
very much.
Thanks, DCJ. Good morning, Advocate Brunt.
Good morning, Commissioner.
Mine is just on the issue of gender specifically. There are 2 out of 7, 2 of the 7 judges are at the Gqeberha bench are women. Do you think that is adequate?
I don't think that's adequate, and the reason I say that is if you look at the composition of gender in South Africa, for example, we're sitting at approximately 51% are women and 49% are men. So the bench has to be reflective of that insofar as it is possible to do so. So there's certainly a disparity between the number of male members of the bench and female members of the bench in the Gqeberha bar, at the Gqeberha bench.
Okay, but just, I was a bit surprised in your response to Commissioner Matolo Dlepu's question relating to the shortage of women silks, that you didn't really have much to say. So my concern is, if you're concerned about gender or representation of women, isn't that something that you should be concerned about and be thinking about and suggesting solutions to, rather than just saying, well, I don't know?
Perhaps I didn't understand the question correctly. It's certainly not a case of I'm sitting back saying, I don't know. I think first and foremost, what's important is that we foster an environment where there can be strong female practitioners, which would lend itself to the appointment of silk. And quite certainly that has been my experience at the Gqeberha bar. We have strong female practitioners, and there certainly are a number of up-and-coming female practitioners who will be able to avail themselves for silk status. So I think that's really where it comes from, is that I haven't seen an issue at my local bar, because everybody has done what they can insofar as transformation is concerned. And certainly from the time that I joined the bar in 2010 to now, there's been a massive shift in a male-dominated bar to something that is more representative of our community. And certainly the female practitioners have been provided with the opportunities that need to be provided to them to enable them to reach the status, to enable them to take silk. I hope that...
Okay, how many male silks have you got at the bar and how many female?
We only have 2 female silks. I'm not sure of the actual number of male silks.
Roughly?
Roughly about 8. We've seen female practitioners. There was one female practitioner which would have been eligible for silk, but then she joined the bench.
So what has been done to encourage women advocates to take silk?
I think the main problem that we have at the Gqeberha bar is that we have a very bottom-heavy composition of the bar. So there are a lot of female baby juniors. There are a lot of female middle, say, senior juniors who haven't quite reached that stage of their practice. But just with the natural progression of time, certainly within the next 2 or 3 years, that's going to become a reality, and there are going to be a number of female practitioners who will be able to take silk.
Okay, thank you.
Thank you, DCJ. Good morning, Advocate Barnes.
Good morning, Commissioner.
I just want to check that I understood your answer to the Deputy Minister correctly, that in your assessment, the environment at your bar is such that it allows women to develop and to prosper, and their practices to grow.
That's correct.
So you don't see yourself as having suffered any kind of structural difficulties in building and maintaining a busy civil practice?
I must be completely honest, I haven't had any difficulties. In fact, I've found the members of the bar to take young female practitioners under their wing and involve them in their matters, to assist them in the attainment of skills that are necessary. And everybody has always had an open door policy and has made it clear that if there's anything that we require, we must please seek guidance. And in that way, certainly I've never experienced it.
Can I understand, as I understand your application, you have one appearance in the Constitutional Court and one in the Supreme Court of Appeal?
Yes, one in the Constitutional Court and 2 in the Supreme Court of Appeal.
And in all 3 matters, you were led by a SILK?
That's correct.
Have you ever appeared on your own in the SCA or in the CC?
I unfortunately haven't had occasion to do that. I was briefed in a Supreme Court of Appeal matter in which I was going to appear on my own, and that was in the 3rd term of last year, but unfortunately, or fortunately, I had taken up the acting appointment.
And why do you think that is, that you have never had the opportunity to appear in either the SCA or the CC? I
don't really have an answer for that other than to say that perhaps my practice wasn't at the time viewed as something where the attorney would brief me on my own for the Supreme Court of Appeal, and certainly my practice has come to that level, which was why I received that brief.
DCJ, I'm going to leave it there. No further questions.
A follow-up, CJ? Follow-up, DCJ? Judge, I just want to ask something based on what Commissioner Pillay said. In South Africa today, there is a worrying issue that it's good when people say women are being assisted, but there is this concern that not women, or not all women are being assisted, especially black women are being assisted. I just want to understand, when you are saying that there are no, or you personally did not experience that structural issue, what about black females in the bar? Do we have a situation whereby white senior counsels are also affording them the opportunities that they afforded you?
Again, I can only answer from a Gqeberha bar perspective, and certainly there's been a very large shift to affording young black women those opportunities, and they routinely appear together with white male silks in various matters across the board, in the High Court, in the Appeal Court, in the Supreme Court of Appeal, and the Constitutional Court. And it is warming to be able to see that that transformation has taken place.
Thank you very much. Thank you, DCJ.
Any questions from this floor, colleagues? Colleagues on the virtual platform, do you have for this candidate?
It seems there are no questions, DCJ.
Thank you, Commissioner Barnard. Well, oh, did I hear a voice?
Yes, it's Premier Mabuyane.
Yes, Premier.
Just a comment, probably might not necessarily require a response to advocate the Barnes. Good morning. I didn't greet you earlier on. My apologies.
Good morning.
I've learned that you have done a lot of work in helping young disadvantaged girls, particularly from Motherwell, to become lawyers. Is that true?
That is correct.
Yeah. Okay. Thank you very much.
Thank you.
It does appear that we've reached the end of your interview, Ms. Spence. Thank you so much for making the time. I've enjoyed your answers.
Thank you so much, and
counts
thank you
for
very much to
everything.
the Commission for having me. Thank you.
Right. You're excused.
Your mic, please, DCJ.
May I ask those who are not members of this commission to please clear the room so that we may deliberate? Too much for the alert, Commissioner Malem. You can blame the Deputy Minister for what just happened. It's not my fault. Good morning, Ms. Matava.
Good morning, DCJ.
How are you?
I'm good, and how are you?
I'm fine, thank you. How do you feel? You look a bit nervous.
No,
If you are, you have no reason to be. You're in good company.
No, I'm settled.
Good, good. You are a holder of an LLB degree which you obtained from the University of Venda in 2001.
Yes.
And just looking at the trail of your CV, you went directly to do your articles
Yes.
with Legal Aid South Africa.
That is so, DCJ.
And after obtaining your articles of clerkship, you joined the National Prosecuting Authority.
Yes, that is from 2004 until 2013.
2006, as a regional court prosecutor.
Yes, I've actually prosecuted in both districts and regional courts.
All right. And what happened between 2006 and 2013? Your CV reflects that you're a relief prosecutor, or what does that mean?
A relief prosecutor simply means you are granted relief duties to assist in different courts of the said cluster. So I was actually a relief prosecutor in the Twando cluster in both district and regional courts.
I see. And that was for about 7 years?
Yes.
All right. And then you decided to take the leap and join the bar?
Yes, DCJ, I actually decided to take the leap, although it was a bit challenging because I'm from Limpopo. And in Limpopo, by that time, we did not have any bar that offered pupillage program. So I had to leave everything and go to Joburg to go do pupillage.
Well, I had to do the same. But you did not stay in Joburg, it seems. You went back to practice in Limpopo.
I was very fortunate, DCJ, in that the year that I was doing my pupillage, it was the year that Senior Counsel Mukari and some other members of the Johannesburg bar and different bars had decided that they would want to form a bar in Limpopo. So that to me came as an advantage to say, now it's time to go and serve your people at home.
Yes.
I then joined the Polokwane bar.
When was that?
It was in 2015. My pupillage was in 2014.
Yes.
Then I was a member of the Polokwane bar in 2015.
All right. And how many were you in this newly formed bar, if I may ask?
We were very few, DCJ. We were actually less than 30, if my memory serves me well. And we were very few women in the group.
Yes, I can imagine. All right, and that's where you have been since?
Yes, that is where I've been since.
You have had an opportunity to act in the High Court.
Oh, before that, DCJ, we have also, from the Polokwane bar, we've now started a new group in Toendo. So I was one of the co-founders of the Toendo group of advocates.
Right.
So I'm both a member of the Polokwane and the Toendo bar.
Good progression. All right. As I was asking, you started acting in the Limpopo High Court in July 2019.
Yes.
And how long was that stint?
It was from July 2019 up till December 2019.
And you were invited back in 2021?
Yes.
For how long?
I think it was a period of 5 months.
So you've clocked almost a year.
Yes, and I'm also currently, again, I've been called to act in the Thando High Court. So beginning of this term, I'm seated at the High Court as an acting judge there.
Oh, I see. What kind of work have you done in the High Court during these acting stints?
Within our division, Limpopo division, one is very fortunate because the then judge president could give you an opportunity to be seated in both the opposed role, unopposed civil trials and criminal trials. So I've had an opportunity, and even your appeals and your full bench appeals, and inclusive of reviews. So I've done quite a number of nearly all the matters.
All right. And have you written judgments?
Yes, I've got 25 penned judgments and about 10 extempore judgments.
Okay. In what areas of the law, if I may ask?
I've got 3 written judgments in civil appeals, 3 in civil trials, 9 in opposed motions, 10 in criminal trials, and in the civil appeals, I even had an opportunity to pen a judgment on the full bench, as well as on the criminal appeals.
Okay. Did you inherit any reserved judgments?
No, I do not have, besides a pending matter before me at the Thando High Court, because the day I resumed duty, I was placed on the criminal roll, and I had about 3 matters, and I had to request from the prosecutor as to which matter had since been long outstanding on the roll. And I noted that it's a matter that had 30 counts, dating back, the date of commission, some of them were committed in 2011. So we then and there on that particular date started with the trial of the matter. And when I postponed the matter on Monday, the state was already leading evidence in respect of count 14.
Okay. Well, I forgot to ask you about one very important aspect of your CV. You're a mom.
Pardon?
You're a mother. You have 3 children.
Yes.
But the youngest is 16, so they're not so young.
Yes.
All right. How have you found juggling motherhood with the rigors of practice?
The one that is now the youngest one, I fell pregnant while I was still a prosecutor, and I was a relief prosecutor. So while I was still on maternity leave, the chief prosecutor requested of me to come back, in that there was a certain court that had challenges. And I did not have issues with that because I had somebody to take care of the child. I just took back my work before my maternity leave could even come to an end. So that is not actually one of the challenges that one can say hinders your performance.
Yeah, that's the story of all working mothers across the world. All right, I will stop here, Ms. Madava, and hand over to the other commissioners to put questions to you.
Thank you,
Starting
DCJ.
with the head of the court to which you have applied. Go right ahead, my sister.
Thank you, DCJ, and good morning, Acting Judge Madaba.
Good morning, AJP.
Am I correct that you are a resident of Thohoyandou?
Yes, I'm actually a resident of Thando. I reside at a village called Makumeke, which is about 15 kilometers from the High Court.
And that most of your professional life you have been working there at Thohoyandou?
Yes, I've been prosecuting around Thando, and as a practicing advocate, I'm briefed by local attorneys in Thando, as well as state attorney in Thando and Polokwane.
And how often have you appeared in the Thohoyandou High Court?
In a week, I can say I appear about twice in the Thando High Court.
Per week?
Per week.
I'm happy that you have realized the backlog that we are having there at Thohoyandou, and that in the recent report we have been reported as one of the underperforming courts.
Yes.
And you are correct that some of the cases started in 2011, 2010, 2017, and they have been on that roll for quite a number of times. There are matters which were postponed 30 times without even a plea. And then what I want to know from you is how do you intend to deal with the backlog that is there at Toyandu, especially in the criminal court?
IJP, I've got vast experience in criminal work, both as a prosecutor and as a practicing advocate. I've noted prior my resumption as an acting judge, the fact that the outstanding criminal roll, it's really bad. Hence, the day that I assumed duty, I had to come up with a mechanism to say, out of the matters that appear before me, I need to take preference of the long outstanding matters. Because if you don't do that, with criminal matters, along the road, some of the witnesses lose interest, some of the witnesses might even pass away. Of crucial, some of the accused are in custody. And if such matters are not given preference, and if our role is not performing well, then we are not doing justice to our people. So my take in trying to reduce the role will be, besides the challenge of load shedding that we have, when I resumed duty the first day, starting with the matter that had 30 counts, I even suggested that we should start our courts at 8:30. Unfortunately, when we came, the schedule had changed and electricity could only resume at 11. So I've actually tried and put up skills to say if we are to start our courts a bit early and make sure that we proceed, then that will assist with having our matters finalized. The other thing that I've noted is what could also assist is us having judicial pre-trials with the DPP or the prosecutor's consent. Because at that judicial pre-trial, you are able to check as to what are the challenges. And in me proceeding with the criminal matter, just along proceeding, when witnesses are already done, it's still about 2 o'clock, you are still ready to proceed, then the prosecutor will be telling you, we were only able to secure 3 witnesses for the day. So you are then forced to have the matters postponed. But I'm willing to take up responsibility with the experience that I possess to clear up the criminal role.
Sometimes we have a challenge with the CCTVs, and we have to move from Toyandu High Court to the Sibasa High Court so that we can go and take the evidence of young children there because their CCTVs is always in order. Are you willing also to move from Toyandu to Sibasa or to the nearest court where they have a working CCTV to deal with all those matters that involve children?
AJP, I'm also aware of that challenge that you've just alerted. Let me say from the Tondo High Court to Sibasa Regional Court, it's less than 5 kilometers. Yes. So that to me will not be a challenge, as long as we are able to safeguard the evidence that has been laid to form part of our record as we go along, to try and not lose up the recording.
I never sat with you in the appeal court, but I had the opportunity to see your reviews. You brought some of your reviews judgments to me to co-sign. And I must say that it was seldom that I have to correct. If I have to correct, it will be maybe sentence construction or typo and so forth, but I didn't do much work to restructure your judgment. Now, on coming to civil, I've noted...
Sorry, JP, there's a complaint from this end of the table that they can't hear you.
They can't hear me.
Yeah, just bring the mic closer to you.
Thank you. Now, coming to civil work, how often do you appear in the civil court?
AJP, my briefing work from state attorney varies a lot. I've got a lot of unlawful arrest matters, I've got a lot of medical negligent matters that I deal with. So with your civil trials, I do not have any challenge with conducting such matters.
And I noted that you have attached judgments of dealing with medical negligence to your CV.
Yes.
And I noted that we have many cases that we deal with medical negligence on the roll pending at the Thohoyandou High Court. And some of them have been pending for long. And somehow there is no movement as far as those matters are concerned. I was just trying to find the reason why that is the case, but I've noted that it might be because there are only 3 judges there. 2 are always in the criminal court, and 1 who's doing civil will do everything civil. So there won't be much time to deal with long trials. And we need somebody who can have a strategy on how to go about civil trials, especially medical negligence, which involve children. Do you have a strategy on how we can go about and see to it that these matters are attended to?
IJP, I've realized that as a judge, one would need to sensitize medical negligent matters, especially wherein children are involved. If these matters are prolonged, along the way, you tend to lose these children through death before justice can actually be served on them. So with my experience and the judgment, as well as my exposure in regards to medical negligent matters, I will actually, there's actually a formula that has been introduced by the senior judge in Thohoyandou. He's trying to recall matters that have been stood down or set down until 2025 and even 2024 to bring up the parties to sit down in a judicial pretrial and see what are the issues, can't we recall these matters and set them down for a nearer date. During the course of the term, when one is done with the term, we've got recess. And once we've noted and marked those sensitive or long outstanding medical negligent or civil trial matters, I'm willing, AJP, to avail myself doing research and proceed with the matters.
And you realize that you might come and do them pro bono?
Yes, I'm willing, because I've been on the Thohoyandou bench pro bono at some time. I would not have a problem with that.
What is your weakness?
My weakness is I would want to see things being done at a convenient or the soonest time. So if it can be done due to my part, then I feel a bit down. But if it's not due to my part, then you find there's nothing that I can do about it.
Thank you, DCJ. I've got no further questions.
Thank you very much, AJP Semenya. Mr. Singh?
Thank you, DCJ. Good morning, Advocate Madava.
Morning, Commissioner.
Traditional leadership is an important and strong institution in the Limpopo province. We have almost 200 traditional leaders, including kingships and queenships. Take us through your experience of how many matters you've presided over in traditional leadership and how many judgments you've penned, please.
You're quite correct, Commissioner, to say in Limpopo, traditional leadership, it's quite the business of the day. As a practicing advocate, I've got a lot of urgent matters that were urgent, wherein you find traditional leaders themselves are fighting. I've got matters wherein there are reviews brought about by traditional leaders and candidates who feel they are the ones that should have been recognized or appointed. So I have experience in such kind of matters wherein traditional issues are concerned. And in regards, or to be particular to Thohoyandou, I am actually a vendor, so the vendor custom, it's accustomed and well known to me.
Thank you. Have you presided over any traditional leadership matters in your acting stints?
I've presided in about 2 matters. I think one of them was an urgent matter in Polokwane, and the other one was just an opposed motion that involved traditional leaders.
Thank you. My last question to you revolves around the comment made by the Limpopo Society of Advocates at point 15.15, paragraph 15.1. Point 1.
Yes.
It reads, our overall view is that the candidate needs to gain more experience before she can be a judge. The bench needs to have judges with all necessary skills. The bench to appoint her will not send a good message to society at large. May we have your comment with regard thereto, please?
I actually checked the comment, Commissioner. However, if we can go back to the very same comments in paragraph 3.2, what they say or submit is to the effect that my appointment at Thoyando would actually send a strong message. So their conclusions at the end of the day, taking into account the overall rating or comments about me, their decision at the end, I actually am a bit puzzled, because they actually state that punctual in court, my judgments are submitted in time, and that I'm a black female. So their overall comment or the underlying comment to say I'm not a suitable candidate does not actually merit to the contents of their comments.
Thank you, DCJ. That is all from me.
Thank you, Mr. Singh. Mr. Nyambi?
Thank you, DCJ. Morning, Advocate Mataf.
Morning, Commissioner.
If you can share with us your understanding of the doctrine of separation of powers.
The doctrine of separation of powers, actually, it's enshrined in our Constitution to say there are actually 3 arms in government, which is the legislature, which makes the law, the executive, which makes policies, and the judiciary, which tries the matters.
Which one of those is led by 2 people? Arms of the state.
It will just be a guess, Commissioner. I would guess it might be, or let me not even guess. I'm not sure at this stage, Commissioner.
My last question. We know that Limpopo, it's a vast rural province like my province. So something that as you are from that province, it's access to justice. Any particular significant thing that you know that is impediment to the rural masses to have access to justice that you can think of and share with us?
It is indeed true that Limpopo is quite a rural area. And one should state that if the people of the said Limpopo province do not have access to justice, then that will be tantamount to a denial. Access to justice at the end of the day would mean if people are bringing their matters to court, they need to have them speedily resolved.
Thank you, Advocate Madam. Thank you, DCJ.
Commissioner. APP, is a follow-up? Go ahead.
Would I be correct to say there is no arm of the state that is led by two people?
Hence, Commissioner, I actually said I do not even want to guess, because in my mind I was thinking the legislature is not led by two, executive not two, judiciary not by two.
Thank you.
The DCJ, my question was basically along these lines. If you allow me, I can follow up and I forgo my opportunity.
I'm happy with that arrangement.
Yes. Advocate, I see that you have an LLB degree.
Yes, Commissioner.
Now, the lawyers that I meet and talk to, they are furthering their studies, and they say to me they want to widen and broaden their theoretical perspectives on the issues of the law. And there's nothing wrong with that. Why are you not doing the same in terms of advancing your academic career? Is there any specific reason?
Commissioner, besides furthering my studies, maybe in terms of having an LLM, there are courses, short courses that one can take to further their studies, depending on your interests. For instance, for example's sake, if I'm interested, let's say, in corporate law, labor law, or medical negligence, then I can take up short courses. I've actually not considered registering for the master's degree, to be honest.
Now, the theory that Commissioner Nyambi is raising of the separation of power is a long-standing theory of law. They say it originates from a French philosopher, Montesquieu. They call it trias politica. Do you know exactly why it was designed that way? Why there was a need for a separation of powers between the arms of state?
Commissioner, I believe that before South Africa was declared to be free and before the Constitution was formed, there wasn't anything like a separation of powers. The Parliament by then could make laws or even enforce. So hence, the separation brings about responsibility. The legislature has got its own responsibility. The executive, as well as the judiciary, has its own responsibility. So it's about responsibility and accountability at the end of the day.
I don't think that you are answering my question. What you are saying now, it is about the legislative supremacy of Parliament. And in my view, it has got nothing to do with the separation of power between the three arms of Parliament, the three arms of government. My question is, why the need to balance the separation of power between the three arms of government? That's the question. If you want us to talk about this one that we are referring to, what Parliament did before the advent of our new democratic dispensation, we can talk about that. But in this case, I want to understand this long-standing theory that I talk about. Do you know why was the need to have that separation of power?
Commissioner, I'm not sure if maybe I'm not understanding your question, but according to my view, the separation was there in order to have separate arms of the government to take up responsibility for their actions.
Okay, then it's important what other lawyers have told me. It's important, therefore. DCJ is okay. Thank you very much.
Thank you, DCJ. Good morning, Advocate Madaba.
Good morning, Commissioner.
Just one question from my side. In book 1 of 1, I think it's page 13, you indicate that you have had a few matters wherein constitutional law was an issue as an advocate. That's what you say.
Yes.
Now, one of the cases that you dealt with is the high quality school versus MEC of Education.
Yes.
Yes. Now, our constitution makes provision for the sacrosanct or the sanctity of the values like rationality, transparency, and the rule of law. So now what I want to check from you is as to whether rationality, did it play any part in you setting aside the decision by the MEC of Education to withhold the matric results?
When I was vested with the matter, my mind actually went to the provisions of the Constitution that the said learners had the right to education. These were actually matric learners who had written their exams, and when results were released, theirs were withheld. So when I was vested with the matter, I then noted we've got a lot of things at stake. These are learners who are supposed to register at tertiary level. And the reason why the MSc had withheld the matter was due to allegations that the paper had leaked and they were still yet to conduct the disciplinary inquiries. So now the question was, in as much as you still want to conduct inquiries and haven't found the learners guilty, what now about the right of the learners who still need to register at tertiary wherein the said registration time closes? So I would not say I was actually rational about the matter, but just trying to enforce their rights as contained in the Constitution.
But I guess you might have also considered as to whether is there any rational connection between the decision taken by the MEC and the facts at hand, which ultimately influence your decision to set aside the decision by the MEC.
I was actually counsel in the matter. I did not set aside any decision. I was counsel in bringing up the urgent application to have the results released. I was not an acting judge on the matter.
But you agree that the issue of rationality could also be another ground upon which your case was centered around?
I cannot dispute that, Commissioner.
Thank you, Advocate Padawa. Thank you, DCJ.
AP Betze.
Thank you, Deputy Chief Justice. Good day, Advocate Matava.
Good day, Commissioner.
I've got two questions for you. The first one seeks to test your assertion that you have got vast experience in criminal law. Supposing you sit as a member of an appellate court in an appeal by an accused person against sentence, under what circumstances would interference with the sentence imposed by the trial court be warranted?
Commissioner, in sentences, there are offenses wherein minimum sentences have been provided. So if a matter is brought to me on appeal in regards to sentence, the approach is to check whether the presiding officer or the magistrate that imposed the sentence actually considered the provisions of the Minimum Sentencing Act, whether or not there was a balance between the personal circumstances of the convicted, whether or not the interests of justice, the victim was also considered in the sentence. And if the sentence imposed brings a shock to the community or it does not, then as an appeal court, you check into such kind of irregularities.
Okay. Generally, where the Minimum Sentences Act finds no application, under what circumstances would interference be warranted?
Generally, under where the minimum sentence does not apply, as an appeal court, you check into whether the sentencing court had actually applied its mind into checking the submitted facts in mitigation as well as those submitted in aggravating, and to check if whether or not the imposed sentence is just under the circumstances.
Thank you. My second and last question. You are presiding in a civil trial concerning a delictual claim where negligence must be established by the plaintiff. Under what circumstances would liability for negligence arise?
The issue in matters where negligence is concerned, one needs to check as to a reasonable man under those circumstances. Could have a reasonable man tried and have done anything to safeguard or to have the negligence not to have occurred? So it's actually to check whether a reasonable man in that position exercised whatever diligence or skills that were in their position.
Just as a follow-up, does the often quoted case of Kruger versus Kutse, a judgment of Holmes J.A. long time ago, reported in 1966 to ring a bell?
Commissioner, at this stage, to be honest, it doesn't actually ring a bell.
Thank you.
Thank you, AP. Deputy Minister.
Thanks, DCJ. Good morning, Acting Judge.
Morning, Commissioner.
Just following on from Commissioner Nyambi's question on the heads of the arms of the state. The President is the head of the executive. The Chief Justice is the head of the judiciary. Who's the head of Parliament?
Commissioner, can I come back to that? Now my mind is a bit blank.
Okay, well, look, in terms of Section 42(1) of the Constitution, Parliament consists of the National Assembly and the National Council of Provinces. So it has two heads, the Speaker of the National Assembly and the Chairperson of the NCOP. I just thought it should be...
Thank you, Commissioner.
I should put you out of your misery on that one.
Thank you so much. Thank you so much, Commissioner.
But my main question is just on the issue of minimum sentences and substantial and compelling reasons to deviate. What would you see as substantial and compelling reasons to deviate? Examples, sorry.
Commissioner, substantial and compelling reasons are not actually described. It actually depends on the person that is before you. Substantial could mean, I once had a matter wherein I think it was a murder trial. I was actually for the accused. And the circumstances surrounding the commission of the offense, that yes, he might have been found guilty of murder, but then somehow the intention was not to commit the said murder. the personal circumstances of a person as well differs. You might find that an accused person, let's say, for example, a 70-year-old has been has been found guilty. Taking into account his age, maybe his medical conditions, the fact that he could have been a first offender, the fact that he does not have any previous convictions, then those can be counted in as exceptional circumstances.
And you are familiar with State versus Machichi, the SCA judgment on minimum sentences, where the court said courts were not free to subvert the will of the legislature by resorting to vague, ill-defined concepts such as relative youthfulness or other equally vague and unfounded hypotheses that appear to fit the particular sentencing officer's notions of fairness. Predictable outcomes, not outcomes based on individual whim, were foundational to the rule of law, and that lay at the heart of the constitutional order. I'm just raising it because there have been some judgments from the Limpopo High Court overturning minimum sentences, which I think should be debated, and it is of concern that minimum sentences are quite strict. That's the intention of the legislature. If somebody commits a rape of a child, unless there are substantial and compelling reasons, they should be sentenced to life imprisonment.
That is true, Commissioner. When the said Minimum Sentence Act was legislated, it was actually for the said purpose, to say as judges or magistrate, you're not to lightly deviate from the prescribed minimum sentences.
Thank you, Acting Judge.
Just before I forget, in response just now to one of the Deputy Minister's questions on what constitutes substantial and compelling circumstances, you made reference to exceptional circumstances, and I want to take that as a slip of the tongue, or did you mean that exceptional circumstances are substantial? Is it the same thing?
Exceptional circumstances.
Are they the same thing as substantial and compelling circumstances?
No, it's not. It was just a slippery of the tongue.
Okay.
Thank you.
Thank you for that clarification.
Thank you, DCJ. Good morning, Ms. Madava.
Morning, Commissioner.
Yes. I want to propose something to you for your comment, and then I'll explain, I'll tell you why I'm proposing that. I want to propose to you that perhaps your application for judicial appointment comes too early in your professional life, and you should perhaps get more training through acting positions and the SAJA training for aspirant judges. And then I would ask for your comment when I'm done telling you why I say that. I propose that. Looking at your judgments, there are very serious problems of form and substance about the judgments that you've given us. And one has to, because these are the judgments that you have put forward, one has to accept that you consider these to be your best judgments. Otherwise, you wouldn't have put them up. That's the basis on which you put them up. And the issues of form, I won't take you through all of them, but just by way of example, your Molokome judgment, you know the judgment that I'm talking about. This is a father whose wife died in hospital and brings a claim, a dependence claim. You remember that?
Yes.
There are all sorts of errors. It's quite a messy judgment, and I use the word messy not in any disrespectful way, but to make a point that it's not a well-prepared judgment, and it has basic problems such as paragraph numbering. You've not done that. You do that and then you stop somewhere, and then you just carry on writing. There are all sorts of typos and all sorts of things. One would expect, this is a public record, so one expects, if this was not an agent application where you had to do the judgment overnight, one expects that you would have had time to go through it and fix whatever problems there were before you finally signed and put it out there. That's a form issue. But also your reasoning and logic and thought process here. It seems to be jumbled up and all over the place. For example, it looks like you're analyzing what the witnesses have said, the experts have said, and then you leave things hanging. And I want to take you to, just by way of example, so that you see I'm not being unfair to you with this comment. In that Mulokome judgment, it starts at page 18, handwritten 18, and then stamped 21 at the bottom, 18 is at the top. If you go to that judgment under the heading discussion, and then you talk about what the expert for the plaintiff says, and just by way of example, you say the first difficulty at page 32, bottom 32, you say the first difficulty with Dr. Prominent's evidence is that he concedes that, and then you say something, you carry on. And I looked for what is the second difficulty. It's not there. You just carry on discussing, and I don't know what you've identified as difficulties. But an earlier problem, in fact, also about this judgment is in your opening paragraphs, you say you list common cause facts, and then in the body of the judgment, you repeat something which is not common cause. You say, this is what he says about this issue, and yet the respondent says something different about it, and he didn't know that when he prepared his report. I think that is not acceptable in a judgment that you're putting out there, but also that you're putting up to us for consideration as a candidate. When you finally find against the plaintiff, you dismiss this action, it's not clear what of the plaintiff's expert evidence you have rejected. It's not clear, and the basis on which you did that. So that's one problem, and that's a judgment in 2020, so it's not that long ago. And then I'll skip the next one, which has its own problems, and go to the last one, which is a Baloyi judgment. No relation of mine. And it has the same form issues, but the big one for me, and I don't understand how you got there. This is a claim against the Minister of Health. A special plea is taken that they've got the wrong party before the court. You deal with that, and then you conclude, you issue you say they're correct. The defendant is correct. I uphold the special plea. If you go to the order, right at the end, at page 52 at the top or 55 at the bottom, you say the special plea is upheld with costs. And then you say, and this is a problem for me, you say the plaintiff is ordered to join the member of Executive Council of the Limpopo province as the defendant. Nowhere in the judgment have you said there was an application in the event that I find, I uphold the special plea, that I should hold that the MEC is to be joined. It's nowhere in the body of the judgment, and you dismiss the special plea, which should be the end of the case against the Minister of Health. At least this action that is before you should be the end of it. But you say you're ordering a joinder of the MEC of Health. Where that comes from is not apparent from the judgment. And I can only put all of these and many errors here to training and experience. It's not necessarily an indication. I wouldn't like to think it's an indication of incompetence, but I think training and something that you can benefit from with training and further exposure through acting appointments. And so maybe this application is premature. What is your comment to that?
Commissioner, if I might start with the last judgment that you referred to. It was a matter wherein a special plea was raised to say a wrong defendant had been cited. Now, my take was, at the end of the day, when one has to meet up with justice. This was a claim wherein, if my memory serves me well, it was a claim in regards to a minor child. I just don't have the facts. And in me ordering that the correct defendant be joined in, I did not want to shut the doors against the poor litigant, according to a technicality that could have been caused by the person who drafted the papers. And in regards to the first matter that you referred to, I should be honest to say that the matter was a bit complex. You would note that it was a medical negligence matter. I had to take my time to research, familiarize myself with the medical terms after having had evidence, and to consider the expert evidence, the expert opinion that was brought before me. With the issue of numbering, I just want to believe that that could have been an error on my part or on the secretary that assisted me in typing out the judgment, that I should have checked and made sure that the numbering is correct.
Yes.
But I would want to say that I am ready for this position, and with the mistakes that you've shown me, and with the practice and experience that I've now obtained ever since this judgment was written, I believe this is a mistake that I haven't done up to so far. And I would assure the commissioners that I've gained the relevant and enough experience, because these are judgments that I penned down during my first acting stints.
Yes. Can I just and this is just a last observation. On that last judgment where you say you think in your recollection it had to do with a child's claim, none of that is in this judgment. There's absolutely no explanation, even if you could do what you've done, which is to order that the MEC should be joined, even if you could, which I don't think you could. Even if you could, nothing in this judgment explains why you conclude that way with that kind of order B. It says nothing about what this claim is about. You say there's a claim against a minister, a special plea was taken, and this is the special plea, and I uphold the special plea, and I order the MEC should be joined. That's all that this is, and I'm uncomfortable that you're not accepting the fundamental flaws in these judgments. You're not accepting that. And in my opinion, that closes the door to growth and development and further training if you do not accept. And you make an excuse about the first judgment. You say it's my PA. No, it's not. It's your judgment. It's your judgment. You signed it. It's completely unacceptable that you would say it's my PA. It is your judgment. Thank you. Thank you, DCJ.
Commissioner, I own up. I accept my mistake. It's not like I'm trying to shift the blame.
Thank you. Thank you, DCJ.
Follow up.
Thank you, DCJ. Advocate Madava, it's just a follow-up to the question posed to you by Commissioner Baloyi. Reading your judgment, do you accept that the MEC for Health was not before you? He was not given an opportunity to present his or her case, and now he is faced with this fait accompli that he is a party to these proceedings?
Commissioner, the special pleas that were before me were that of non-joinder. The defendant was saying the MEC of Health should have been joined and misjoined. Hence, I ordered that the MEC of Health be joined due to the fact that the special plea was that there's this non-joinder of the MEC of Health.
But the essence of my question is that the MEC for Health was not afforded the opportunity to speak for himself or herself on that issue.
That is so, Commissioner.
Thank you. Thank you, DCJ.
No, just a quick follow-up. Commissioner Baloyi says these judgments that you have put here, they were not put by anyone else but yourself. And you regarded these judgments in a way as your best judgments that you can put forward. Then when mistakes are shown in those judgments, you say, no, those are old judgments. I've since improved. Why didn't you bring the improved judgments instead of bringing the mess that has been presented before you? Because if you say those are old judgments, meaning they are new judgments which have extremely improved and you have not brought them to our attention, how do we confirm that indeed you have improved from all those mistakes which were pointed at you?
Commissioner, if you can have a look at the judgments that I attached, I tried to spot out different kinds of matters. The one that Commissioner Nyambi pointed out is that of medical negligence, which was a civil trial, and I've also attached a criminal trial judgment, and I've also attached an opposed. So I was trying to show to the Commission the different kind of judgments that I've written, regardless of maybe the flaws of that have been shown to me, which I acknowledge. However, I can state with certainty that I've actually improved, and my reason of attaching these judgments was to reflect on the different kind of judgments that I've written.
Follow up,
Thanks,
CJ.
Commissioner-
Follow up, CJ.
Yeah, before that, JP Mlambo.
Thank you very much, DCJ. Good morning, Advocate Madava.
Morning, JP.
It's a follow-up question, and I'm here representing heads of courts. And one of the objectives of me being here is to also see that people who are interviewed and who are recommended are actually ready for permanent appointment. So my follow-up is, have you ever attended a judgment writing judges training course?
JP, I was, after this, the judgment that I attached, I attended the advanced training. You were one of the facilitators in January 2021, 2020 or 2021. The advanced training course for aspirant judges.
Yeah, I'm talking about, there was a course on judgment writing there.
Yes, I've attended to that one.
Now, you acted after that training course, didn't you?
After that training course, I acted pro bono in Twando and only came back now in 2023.
Is there no judgment that you could have attached that could have shown us that the advanced, and you were lucky you went into the advanced one, judgment training course you attended helped your judgment writing?
After that training, JP, I do not have any judgments that I compiled in Twando because I was actually on pro bono and assisting when challenges or when there was a shortage of judges in Twando, and I was actually placed in the unopposed role.
I see. Thank you, DCJ.
Thank you, JP. Prof. Marumo.
Thank you very much, DCJ. Mine is also a concern in relation to the structure of your, and I accept that there are most of the judges, including those perhaps in the Supreme Court of Appeal, when they structure their judges, just before their first paragraph, mostly they don't put anything there, and some will put background or factual, something like that. But what concerns me is, in your judgment, you have these three headings. You have the law on the one, you have legal framework on the other, and you have the legal test on the other one. But it seems to me that after that particular subheading, there is nothing that follows in terms of dividing what you are doing. After that subheading, you go on and on up to the time when you are giving the order. So it appears as if the order is inclusive to the law that you have just provided. And it is difficult to realize as to when does the discussion of the law or the statement of the law starts and the discussion of the law commences and the marrying between the facts and the law actually is done. I thought it was something that is quite disturbing about how you structure your judgments. Any comments?
Commissioner, I believe I've made my submission in respect of that judgment, and I wouldn't like to take it any further.
Accept that, it's fine.
Okay. Thank you. There was a hand up in the virtual platform. Do you still want to ask the question, Commissioner, whoever you are out there?
Yes, Chief Justice, if I may.
Yes, go ahead, Mr. Bernard.
Advocate Madava, the various law bodies, the LSSA, the Limpopo Society of Advocates, and even to an extent, probably Nadel, but there is an indication that Nadel refers to a certain evaluation of expert evidence and test of negligence on that seems shaky, but the other society and the Law Society and the Limpopo Society of Advocates indicate that they seem to feel you need more time. And I mean, these are colleagues that appear in the court, that have experience of the court and so on. What would you say to allay their fears to convince or persuade the JSC to still, despite those comments, go ahead with an appointment?
Commissioner, with Nadel comment, I should state that on paragraph 4 of their comment, that is now found on page 54, where they say, reasoning in the Mukute matter against the MEC for Health regarding negligence, the test, and they go on. I should state that this is not my judgment. I tried to check in all the judgments that I've penned, and I couldn't find. It's unfortunate they did not even include the case number, which could have made it easier for me to locate the said judgment. But with all the judgments that I've penned, this is not one of my own. However, to try and convince the commissioners that I'm ready, I will try and Commissioner Baloyi to say your mandate in requesting us to celebrate 100 and more, that campaign. I was fortunately tasked by our AJP to be one of the facilitators in Thando High Court. We have done that. We celebrated that this Monday, and our main focus was to say we should invite learners from the local university who are women to try and alert them about the regulation that was passed on the 10th of April 1923, which allowed women to be admitted to practice as attorneys and advocates. So that was done, and it went very well. It was informative in that our main objective was to say, yes, this is 100 years and more after this regulation was signed. But as women, where are we? Are we really winning in this profession? So we had different stakeholders who came and addressed the women. And I'd also want to submit that one who is for transformation. Within our bar, the Polokwane bar, I've been tasked with different peoples over several years. When the bar started, it was only a few chambers that were available, but we had taken up a lot of peoples. I opened up my chamber for any people who wanted to use my chamber. I remember opening it up for 2 people whom I gave my keys and let them use my chamber. Besides that, I was even given a people who was not from our province. The said people struggled financially. I had to come to his rescue and assist him throughout the whole pupillage program. I was also one of the members who seated in the interviewing committee to interview pupils for pupillage program. I even went further in assisting in lecturing them. So I'm here to say with pride that with transformation, I'm putting my hands to assist with peoples around our province. And besides assisting the peoples only, to also assist our junior peoples, because the practicing advocates who are here are quite aware of the challenges that we face as junior advocates to get briefs when one is done with pupillage.
Thank you, Advocate. Thank you, DCJ. I think I'll leave it at that. Thank you very much.
Thank you, Commissioner. Any further questions, colleagues? Ms. Madava, it looks like we've come to the end of your interview, but before I let you go, I just want to send you off with this message. There is indeed an urgent need to advance women, not just in the judiciary, but everywhere they find themselves in the workplace. But women are not given a seat at the table simply because they are women. They must prove that they are able and competent to do the job at hand. Now, you have pinpointed Commissioner Baloyi, who was suggesting to you that you may benefit perhaps from further training, training because, you've had training, further training, yes, and maybe more acting stints, and it does not appear that you agree with her. And I don't know, the commissioner will still deliberate and decide what to do with your interview. I don't know what the result will be, but I just want to implore you to take that advice. It is sound advice, please take it to heart. Thank you so much for making time to attend the interview. You're excused.
Thank you so much, Agent.
time is it? Good morning, it's still morning. Good morning, Ms. Mdluli.
Good morning, DCJ.
Are you well?
Yes, I am grateful.
Well, I'm well too. I see that you're not interested in my health.
Well, one time I listened to one candidate asked, and the reception was like, oh, she wants to know how I'm doing. And I thought, okay, let me not engage much.
Okay.
And instead respond.
All right.
But I'm interested. How are you, DCJ?
I'm very well, thank you.
Thank you.
You are a holder of 2 degrees, an LLB and an LLM.
Correct, DCJ.
From the University of Venda and Universities of Venda and Limpopo, respectively.
Correct.
Is it you who also has a diploma in theology?
Yes, that's me.
I see that you have not listed it. You were outed by some professional organization.
No.
Why have you not listed it?
No, it is part of my CV, DCJ. Even the certificate has been attached to that effect.
It has? Oh,
yes.
My mistake.
I think that's where you're remembering it from.
That's quite interesting. Why did you decide on that diploma?
Well, it's more like a response to a call, more than anything else. When you are in a particular field, training becomes very important for you to be able to trade well and sufficiently in a specific area. So I am a church leader, and I needed training in respect to that, hence the diploma qualification.
I see. You are an attorney by training.
Correct, DCJ.
And you were at the sidebar for how many years? About 7 years.
I was never at the sidebar. I've always been an attorney.
I thought attorneys are in the sidebar and advocates are in the bar.
Well, maybe it's because DCJ, we've got advocates who don't do pupillage, who are called sidebar advocates, and those who do pupillage are in the bar. Hence, I don't want to associate myself with that from the province where I come from, at least.
All right. I hear you. So you were a professional assistant for 2 years?
It's actually for some few months, because I was admitted in July 2008, and I left the firm in December, actually the end of November 2008.
To start your own practice?
Yes.
And how long did you do that?
I'm
Run your
still-
own office, that is?
I've been in my own office from 2008, December the 4th to date. Well, save for the times when I've been acting as a magistrate, as well as acting as a judge.
Wait. Is it not you who act as a magistrate at some stage?
Yes, DCJ, I acted as a magistrate in the then Tabamopo Magistrate Court, now Leboa Khomo, as well as Magistrate Court Polokwane at some time.
For how long did you do that?
The total acting in the magistracy is about 40 months, with Tabamopo having more months than Polokwane. Polokwane, I think I was there for 5 months, and the remainder for Tabamopo.
All right. But then you went back to practice?
Yes, I went back to practice.
All right. In 2015?
No, in 2015, that is when I actually registered my sole proprietorship to an incorporated, hence then it then becomes, I was a director. Throughout, I was a sole prop. Yes.
I'm actually interviewing you based on the application, the JSA application, and it seems there's a disjuncture between it and your CV. But that's fine. We are getting the information we need. I'll carry on with the JSA application because that's what we are asked to complete.
Yes,
You have acted as a judge
correct.
since July 2020. It says here acting judge 27 July 2020 until October 2020. Is that accurate?
It's April 2020 to June. Again, May 2021, from July to September. Another period was the 3rd of May to June 2022, 29th October to 30th November, and lastly, 17th January 2023 to 17th February 2023.
Okay, I understand about the most recent stint. I'm just concerned now about the earlier ones, because as I said, I'm following the information you gave us in your application form.
Yes, the reason why on the form I did not include the October and June one is because I was acting doing a special trial that was continuing. And there was no appointment that was issued, safe to take oath. And I was remunerated for that as well. So that is the one that was outstanding from the application, because the application was at the end of 2020.
Well, it still is an acting stint. Because
Yes, that was
you were finalizing a apartheid matter, not so.
Correct.
Acting as a judge.
Yes.
Being paid for it.
Yes, that's why I'm saying it was an error on my part that I did not include that in the form.
Yeah, but that's not my concern. I understand that. My concern is that the times, these periods you've given now do not tally with what is in the form, the ones that you have actually stated. Because you said you acted between 27 June and 30 September 2020, and then you listed 3 May until 30 June 2021, and you just gave me completely different dates now. But be that as it may, how long have you acted as a judge? Counting now the times that you say you did not take into account because you were finalizing apartheid.
I think it's plus minus 10 months, DCJ.
10 months.
Correct.
Okay. During that 10 months, what kind of tasks were you given? What areas of the law did you get a chance to dabble in?
The first 2 terms I was allocated the criminal trial court. Actually, I did the motion court this year from 17th January to 17th February 2023.
For the first time?
For the first time, yes. And I dealt with both the unopposed motion court as well as the opposed motion court, civil appeals, agent court. Oh yes, in the previous terms where I did mainly the criminal court, I also did some motion court minimally. There was a motion court week that I did, an agent court that I did, and 1 special civil trial. But being placed in the motion court, it was only for this year.
And how many times has that been?
Well, every day for the whole month of, from 17 January to 17 February 2023. So the entire month that I was acting in this year.
You were just in the
motion court, yes.
Okay. And you say you've done appeals as well?
Correct.
Both full bench and full court?
Correct.
Have you written any judgments?
I have not written any judgment. However, during one of the,
At all during all these acting stints? I'm
No,
not
no.
asking just about this term. I'm asking if at any time during
wait, yes,
the
I did.
entire-
Yes, I wrote
How many?
judgments. I think it's about 3,
Throughout the entire period?
correct.
Any of them reported in the law reports?
No,
And I take it that 3 you've written are the ones you have attached to your application form?
yes, yes, they have attached to the application form.
So you've written only 3 judgments so far?
In the full court,
No. Altogether, during your acting stints as a judge?
about 16 written judgments. Those are the ones that I have.
Okay.
Yes. I thought we were still talking about this, the full court bench, because it was a follow-up after that
No,
question.
I'm sorry I didn't make myself
All
clear.
right.
I'm asking about all the judgments you've ever written as an acting judge.
I did not get that part.
Okay.
Sorry.
In which areas of the law were those 16 judgments? Can you recall off the cuff?
Yes, actually,
It's fine if you can't recall offhand.
yeah, I can't recall offhand, but some of them are attached to my application.
You've listed them at pages 11 to 13.
Thank you. Thank you. I'm getting there. Well, my page 11 to 13, it's about the matters I've done and not the judgments per se.
Or is cases in which, judgments in which you've appeared?
Yes.
Not written
Not
yourself?
the written myself, yes.
Okay.
But of the ones that I have attached, okay. There was one I dealt with, I think, with JP Mahoba about a lapse of an appeal and the reinstatement thereof. So, yeah. Yeah, the number. The numbering has changed because of my index, but yeah. Maybe for now it's safe to say DCJ, I can't recall.
No, that's all right. I see that you have young ones. Your children are still quite young. The youngest was 10 months old when you filled in this form.
Correct, 3 handsome boys. The youngest now is 1 year, 3 months. Was born on the 17th of January, 2022. Yes.
You have not found having children whilst in what I hope is a busy practice challenging?
Well, I think that's it's a story of most of women in the profession, and I found that having supportive family members, a partner, assists greatly because the profession is quite demanding on its own. Now, when you go to the bench, it gets crazier because you are present and yet not available at times. So I found it very challenging. I was actually glad that at the time when I had my young one, I was not acting. And the time when I did the other periods were like October last year till November, at least he was now able to sleep at night. You know, babies, there are times where sleeping at night is a luxury. But at the time when I did that, he was a bit better. And now his schedule has changed, so I'm very able to cope.
Yeah.
I did even so, especially in the motion court this year. It has been one challenging period that I would not have made it without the assistance that I've received and the support from my family.
Yeah. Yeah, and to answer the question but I can assure you that, well, it has been my experience at least that it's easier to raise kids whilst on the bench because the work is more structured, unlike in practice where you are pulled from all sorts of directions. So if you are appointed, you'd have an easier run as a mother.
I believe you.
Yeah. All right. I will stop here for now, Ms. Mtloli, and hand over to the rest of the commission. AJP Simenye, do you have questions for this candidate?
Yes, thank you, DCJ. I see you have studied in Venda.
Correct, AJP.
And you have never acted in the High Court there.
Yes.
Have you ever appeared in that court as a practitioner?
I've not appeared as a practitioner in that court, but I'm familiar with the court.
You are familiar with the court?
Correct.
As I agree that you were only allocated the motion court this year, and it was after you have handed in your application, and that for that reason you didn't have any judgment in that field.
Correct.
At the time you were making this application.
CJ?
But now I have searched through SAFLI.
DCJ, we can't hear.
Can't hear me? Oh, sorry. I have just searched through SAFLI and I realized that the last 4 judgments for March are your judgments in motion courts. Did you, after writing that judgment, read it and proofread it? Because I found that most of them had sentence construction were not correct. The way you went through the facts is also not appropriate. And I feel for that reason that you should be granted more opportunity to act in the motion court as well. Do you agree with me?
I think if the AJP could assist me in terms maybe of reference to probably which judgment you're referring
That is
to.
all last 4 judgments on SAFLI for March.
Okay.
For March,
So
yes.
all of them?
All of them, yes.
I find it rather puzzling, but I have proofread it. I type my judgments. Nobody types them for me. I type them. I proofread them myself. So as for your observation, I think it's regrettable. I accept it for purposes of now, since you are not able to
Yes,
refer
this
me.
was your first stint, I agree, in the motion court. I agree with that you did not have much opportunity to preside in that court. And further than that, I did an appeal, criminal appeal with you. And you were the scribe. And I must say that it took me, I had to, the first judgment that you wrote and gave to me, I read it and I had to do much work on it. And this is not only me who's saying that, there are other judges who are also saying that they have to do much work to correct the judgment that you have written. And I also believe that in that field as well, you still need more time to act in that, on appeals as well. Do you agree or don't you agree with me? Because it's not only me. Last week, one of the judges was telling me about one of the judgments that you wrote and handed it over to her so that she can sign if she agrees with you.
Well, I think AJP, It's surprising, I think, because I remember the judgment that you and I sat on. And you corrected, it's just that I don't have the judgment with me, but I keep all the records of my judgments, especially the ones that I'm sitting with other judges, so that for my recollection, I know where I fell short and where the contribution has been. And if I recall the judgment that AJP you are referring to, is the judgment of Dibila, wherein I think your contribution was to the extent of structure to a certain extent, and also you asked me to include a particular citation of a case. And I remember very well in that judgment, AJP, that you were not even in the first instance agreeing with my conclusions of that judgment. And when I insisted on it, you undertook to go and read again. And when you came back after reading, you said, indeed, you were right.
Yes, I agreed with you at the end after going through it again. But I'm actually on the structure. The way you have written it and the way you have structured the paragraphs. And remember that I also said to you, if you decide to write a judgment in such a way that you put headings on it, make sure that under that heading you deal only with what you have said it is on the heading, and not to say this is the heading, but touch on other things as well.
I remember that.
You remember that?
Yes.
I'm talking about the structure only.
Yes, I think if I can continue, because you referred to the other judge as well, and I think that would be that would be Judge Nodie Odendal, which I wrote a judgment in which she was involved in the civil court. And I can tell you, I even have the judgment with me in this building. The structure or her contribution to that judgment was with respect to italize court accrue as well as put in paragraph numbers. I have that judgment with me. And that was the only thing she said to me. So I find it very puzzling that she was able to say that to you and yet not to me when she was sitting with me in the very same court.
Okay, I thought she has discussed it with you.
No, it was not. That's what I'm saying. It's very puzzling.
Okay, I'm sorry about that. You have made yourself available for Toyando High Court.
Correct.
And you are aware that there are only 3 judges at town. You are going to be the 3rd judge if you are recommended and the president signs. And as a result, we don't have the luxury of working in only one court. If you are allocated criminal cases, you may at any time be given a civil trial to do or be asked to do in the annual post and so forth. Are you able to tell us about the incident that happened this year when a senior judge allocated you a file to do when you were not in court on the day? Do you remember what happened?
Yes, very well, AJP. I remember the events very well. I was in chambers busy reading my files for the annual post court for the following day, and Asha came into my chambers with a file and say, I was told to bring this file to you, and I asked, what is it for? And she said, no, they will come and tell you. She left. After some few minutes comes the Judge MG secretary to say, here's the file, they say that you must attend to it. And I asked, why are you not attending to it in your court? Because this is your court matter. And she said to me, they are still busy with something else. And as she left, I thought to myself, okay, I don't know how things should happen. Let me go and find out from the AJP's office. When I came to your office, I actually found Judge MG Patudi complaining to you about me not having received the file. And I waited for him to speak. I think there was an opportunity for me to respond because there was some sort of misrepresentation that was happening there. And I said, no. I came to understand, is this how things are to happen? That a judge who's sitting in court can send a file without any a discussion with me, because my understanding was that as much as I was acting, I'm still a judge, and as a colleague at the time, should there be any request for relief, same should be communicated to me as a judge. But then again, it was yourself who said to Judge MG Patudi that no, what you did, yes, we agreed about it in the meeting that I was not invited to. If you recall, that meeting that you had in January, I was not invited to that meeting, and you are aware of it. There were resolutions that were taken in that meeting that they were not communicated to me. And you said, yes, we agreed in that meeting, but we agreed that that decision, or the decision to take the matter or the file to another judge, must be done through your office as the AJP to avoid abuse, especially of acting judges. And same was not done. And then from there onwards, you elected to proceed with the matter yourself. I think that is the events of that particular day.
I fail to understand that.
AJP, sorry, before you carry on, I think we may be running into slippery ground now. Questions are being put to the candidate about what may be transgressions, and practice is that if a candidate is going to be asked, questions that questions similar to the ones you are putting now, they are given forewarning before the interview. They know to expect, they know what to expect will be put to them, and they can prepare for that. They can even submit answers before the interview itself. Now, questions are being sprung on this witness, and none of us were given any hint that you'd be put. Well, I hope you did give a forewarning, even if orally, but the commission sitting here was certainly not aware that you'd bring this material in the open here. So there may be a big problem there.
I understand, DCJ. I withdraw the question.
All right. Thank you.
I have no further questions.
Thank you, AJP. Commissioner Malem?
I just want to ask one question, DCJ, to Ms. Mtluli. Do you think you've got the right temperament of a judge? It's a question. Oh, sorry.
Thank you, DCJ. Good afternoon, Mr. Mtluli.
Good afternoon, Commissioner.
Traditional leadership is a strong and important institution in Limpopo. We have almost 200 traditional leaders here, including kingships and a queenship. You've said that you've acted for a period of approximately 10 months with 16 judgments. Have any of those judgments related to traditional leadership?
Unfortunately, I have not been presented with an opportunity to preside over any traditional issues, matters before me during the time when I was acting. So none of the judgments that I referred to relates to that.
No, thank you. May I take you to your question at paragraph 9.4 on the question, have any of your judgments been taken on appeal? Indicate with an X, and you said yes. And the following question was, what was the result of the appeal? And your response was, leave to appeal granted only as at the time of this application. The appeal is not yet heard. Perhaps tell us, if you can remember, what is the name of that judgment which was taken on appeal?
It was the Klassen matter.
Okay.
It was a civil matter. It was a Klassen matter. And from what I've heard, the appeal has been successful in that particular matter by SF today.
No, thank you. Indeed, it is Classens matter. The Classen was Johannes Classen was appellant, and Marupini Franz Nakana, first respondent, Minister of Police, second respondent, and Warrant Officer Williams, third respondent.
I'm sorry, Mr. Singh, I don't know about the other commissioners, but I am struggling to hear you.
Okay,
I'm also struggling to hear him as well.
Okay, I'm going to speak a little bit into the mic, DCJ. Yes, indeed, it was the Johannes Classens matter. It's a civil matter for unlawful arrest. What perturbs me is this. Your application was submitted on the 29th of November 2022. You heard the case on the 21st of January 2021. Leave to appeal, you granted leave to appeal, and then the appeal court, chaired by Judge President Makoba, Muller, and Acting Judge Zitole, delivered judgment on the 16th of August 2022.
Yes, I was not aware of that at the time. I became aware when I was busy preparing for the interviews. I engaged with actually my secretary as at the time, who assisted me in that information. So I did not know at that time of the submission of the application.
Mr. Ludi, you were submitting an application to be appointed to the bench. I would have thought that you would have taken care in the information you supplied to this commission. How do you respond?
Yes, I think I've said that at the time when the application was submitted, I was not aware that the appeal had been successful. Hence, I volunteered the information now without you even asking me that because you asked if at the time it was outstanding. I said by now it was successful.
No, fine. Okay, two of your orders were set aside on appeal. The first one, okay, before you go to the first one, what also concerns me is that your first order in a civil case read, and I'm quoting, the defendants are guilty of unlawful arrest and detention. This being a civil matter. Is it not a fundamental error to find a defendant guilty in a civil matter as opposed to liable?
Yes, I think the use of the word guilty could be confused for criminal court language and not suitable for the civil court jurisdiction.
Okay. I mean, fundamental errors like this does not provide the confidence needed. But the confidence needed.
I did not get the first part of your
fundamental errors like this is my comment, does not provide the confidence needed to recommend a candidate for appointment to the bench. What is your comment?
Well, I think that for me would be a fair comment. However, I think the commission should take into account that that was the first judgment that I wrote during the time when I was even apportioned the criminal court role. So there has been great, I think, improvement from then onwards to date, and I don't think I've ever repeated that type of language use error since then.
Thank you. My final question to you is, given the fact that you don't have any traditional leadership experience at bench level, given the fact that your forms are not in order, information is incorrect, how would you respond to the message or to the remarks by the Limpopo Society of Advocates at point 29.1 of the comments on your application? I will read it for you. It will not be an offense if the candidate was to be given more acting stints to gain more experience before she can be appointed permanently as a judge. The bench needs to have judges with all necessary skills. The bench to appoint her will not send a good message to society at large.
Yes, I have seen that judgment, that observation or that conclusion by the society. However, when I read through their comments from the first page going down, it's as if I knew what the conclusion would be at the end. However, the content of the motivation or the objection does not really resonate with the finding, which is that I should not be recommended. Now, acting further definitely cannot be taken away that it will enhance me as a person, and equally, should I be appointed, that will also work for me because I will be sitting daily in that court, being exposed to the matters that appear before court, and I will be able to discharge the duty that is required of a sitting judge. Now, as far as the traditional affairs are concerned, I am born and bred in the village. I lived and I continue to live traditional affairs. I know it from my livelihood experiences, and I'm familiar with the dynamics of the traditional authority, and I'm also familiar with some of the cases that are going on in our country. And also, should the traditional matter appear before me, I will not take it from a position of the law only and the facts before me, but also the fact that I'm conscientized as far as the traditional affairs are concerned. That would assist me greatly as a village girl, for lack of a better word.
Thank you, DCJ. That's all for me.
Oh, thank you very much, DCJ. I have one question. The one I asked earlier. Do you think you've got the right temperament for a judge?
I think I do, Commissioner Malema. That can be seen or observed through my judgments, how I conduct myself in court, how I relate with professionals, practitioners, as well as the stakeholders that are involved even in the running of the court, how I relate with my colleagues. And this comes also from not only now as a judge, but even professionally. I believe I have that good or right temperament to be a judge.
What is your witness? It can also be a witness not knowing your witness.
Yeah, not true that. Because I'm actually thinking that my weakness is my weakness is always trying to make sure that things work the best possible way, even when they are not within my power. That's my weakness.
Thank you, DCJ.
Thank you, Commissioner Malema. Commissioner Marumokai?
Thank you very much, DCJ. Good morning, Ms. Mdluli. I'm this side.
Good morning, Commissioner.
Look, I think the issue in relation to the grammar and formatting of your judgments is an issue that should have been raised with you at the division level and be addressed with. And there might be concerns relating to that, and I will make my submissions during deliberations. But I think it is something that you need to really take to heart. I understand that the language of record is not necessarily our language. And sometimes there might be a greater need for us to really edit the judgments that are written. And I'm speaking from somebody who writes for a living, right? That there are mistakes that can be made. And I'll just give you one example of such mistakes. And these are things that can be corrected. I don't think these are things that you can really be angry with. In the judgment that you penned, just trying to see, it's very difficult on Safi to give a citation, but it's TKM on behalf of KKKY, KKKM. Do you remember that matter? It dealt with the applicability of interim orders.
Yes.
Yes. In the first sentence of that, the first paragraph of that judgment, you write, children are the world's most valuable resources and its best hope for the future. Full stop. Then you say this code, it's not a code, it's just a sentence. Then you say this code ran through the judgment, which leave is sought on and will be running through the spirit of the judgment. And I think that is the concern that is being raised, and that we should actually take to heart and really work on. I don't think it's a criticism that is destroying. It's a criticism that is building. That please take care when you are writing, because these are going to be, and this judgment it has similar sort of mistakes. Because I'm raising this because you were saying perhaps we are not directed to those kind of issues. My last question that I have for you, and that was just a comment. The question that I'm having for you is, in this judgment, you correctly say that generally interim orders are not appealable or are generally not appealable against, right? But there are circumstances under which they can be, and you try to list those. Can you just please explain to me what are those circumstances? Under which circumstances can interim orders be appealed again?
I think one of those is when the interest of justice demands that they should be appealed, because the courts, it's tried that, especially the SCA, warns us against taking matters for appeals on piecemeals. So if the interest of justice requires that the interim order should be appealed, same should be done so.
Thank you, DCJ.
Thank you, Prof. Deputy Minister Jensen.
Thanks. Good afternoon, Ms. Mdluli.
Good afternoon, Deputy Minister.
Mine is a question on substantial and compelling circumstances to deviate from minimum sentences for rape. What would you regard as substantial and compelling circumstances?
Those are usually dependent.
Sorry, DCJ. Sorry, DCJ. The sound seems to be quite faltering. We couldn't quite hear the Deputy Minister's question. Sorry to interrupt.
All right.
Okay, just quickly to repeat, the question was around what are substantial and compelling circumstances to deviate from minimum sentences for rape. I hope that was audible.
Can you hear him now?
Thank you. That's good. DCJ.
Thank you. I was saying, Deputy Minister, that those are usually dependent on a case-to-case basis, because our case law has taught us that as much as the legislature has prescribed minimum sentences to certain offences, it did not prescribe what those are, and it left it to the court to find what would be compelling and substantial circumstances. And our case law also goes on to tell us that in terms of compelling and substantial circumstances, one does not have to look at something that is very out of the ordinary to the normal mitigation principles or circumstances that we look at. For example, I will give, and it does not make it, I must not be confused to be saying it makes it less of a rape, but in circumstances where you find that there was no penetration of the genital, for example, maybe where a person uses their tongue for raping, it is still rape. And it may also depend on the circumstances of what happened in that particular instance, where you find that this was parties who were consenting, but by the fact that that particular party was a young child, makes it rape. Could be one of those compelling things. So in my answer, I would say they are dependent on case-to-case basis, but it's nothing out of the ordinary of what we normally deal with.
Are you aware of State versus Matiti, the 2011 case from the SCA on minimum sentences?
Yes, I recall that.
Yeah, I mean, that judgment was a little bit harder or stricter, as I would read it, on the concept. But just out of an example, for the rape of a child, would you say that the relative youthfulness of the accused, well, any of these factors, relative youthfulness of the accused, that his mother testified that he was of good character, that his girlfriend testified that he was of good character, that he expressed remorse. Would you say any of those are substantial and compelling circumstances in your view?
Under the circumstances that you've alluded to, no.
Thank you.
Thank you, Commissioner Lucas.
Thank you very much, DCJ. Good morning, Ms. Sindri.
Hi, good morning, good day, Commissioner Lucas.
Thank you. It's good to see you here, a young woman with a bit of energy.
Thank you.
So, but I see that you have a practice as a lawyer, and you are aspiring to become a judge. And I've listened to those that have been judges before, asking you, how do you juggle your program? I just wanted to, directly to your firm, wanted to ask you with regards to what programs you have in regards to social responsibility, and also how do you contribute to making sure that you actually mentor other young black women by using the resources that is at your disposal. That was my question. Thank you. Thank you.
Thank you, Commissioner. I think for those that live and work in Limpopo know that I am a mentor to a whole lot of young females, including males from the student chapter of both the BLA as well as Saul. I also mentor young women in the profession. Now, from my law firm, I've had over all the years when I do articles, always make sure that women are taken as a priority. And amongst other things that I do, is to annually have events that are organized by my practice in the communities wherein there's legal education that is provided freely, including some activities, with the latest one being a celebration of Women's Month just last year in the village called Rasiminya Muleji. It was a day filled with aerobics, activities, t-shirts bought for women. Thereafter, there was legal education that was provided. But it does not only end with only the female commissioner. I do that even amongst several communities through the tribal authority, meetings that I make arrangements to and request that I come and give legal education to communities, as well as different and several churches, of which most generally church attendants are women. That is amongst other things that I do.
May I have a follow-up? So my follow-up is just in two ways. You said you are a pastor, and it's actually a very good thing. How does being a pastor assist you in your work as a judicial officer? That is the first one. Secondly, customary law. You say you are doing legal training and things of that. What kind of programs do you have around the whole issue of customary law? Particularly since you said you are a village girl, like you put it, and you grew up in a traditional community. Thank you very much, DCJ.
Thank you. I think the element that assists me in the judiciary from the pastoral side is dealing with people with compassion. That is the element that assists me in the judiciary. Now, with the issues that are customarily based, the when you go down to the communities, the cry that our community members have is that they feel that the courts do not understand their plight or does not resonate with how the people live. For example, I'll give, in terms of customary definition of a marriage, lobola is not part of the essential elements of the definition of a marriage. However, in our different communities, it's a very big deal when lobola is not paid in full. Actually, our gogos and our mkolus don't believe that you have married when lobola has not been paid in full. So, amongst other things, when you educate the communities to say, if you go send delegates to a particular girl's home, you pop out some money, there's an agreement there. Legally, you are married. So you don't have to wait for that particular day when the celebration is going to happen and things like that. And those are some of the things that they have challenges with, amongst others.
Thank you.
Could I just follow up this question of customary law? If, with your permission, Deputy Chief Justice. Thank you. Good morning, Judge Ndluli.
Good morning.
Yes.
Commissioner, it's still Mrs.
All right. Well, yeah, sorry, not judge. Okay, that's fine. Acting judge.
Well, at the moment, I'm an attorney. Thank you. I'm not sitting at the moment.
All right, Ms. Ndluli.
Thank you.
Yes. So you are sitting as a judge, and a case comes where there is a contested rule of custom. Just tell us what steps you are going to follow to resolve the contestation on the rule, and give us the maybe 3 leading cases.
Well, I always start with the Constitution as a point of departure and see that whatever dispute that is before me, does it fall or that it passes through the constitutional master. Thereafter, I will go to the common law that is applicable to the parties that are before me in dealing with custom.
No, sorry, I should stop you because I think this is going to take a long time. This is not a dispute about the Constitution. It's not a dispute about the common law. It is a dispute about a rule of custom. What I'm asking you is, what are the legal rules you will apply to resolve a contested rule of custom, and what are the legal cases that are leading?
I think I'll first employ common law as a point of departure on that custom, unless I'm not understanding you, Commissioner.
No, thank you.
Follow up, DCJ. Ms. Ndluli, I got interested when you started talking about lobola and all those, but I want to ask you on that question, but asking you not from the community's perspective, the views of the communities, but from a legal perspective, and asking you as an attorney and an aspirant judge. When you are faced with a dispute, a marriage dispute, where one party is saying, I'm not married to this person, and the other party is saying, we married in terms of customary law. And the issue before you is divorce, but before that is the declaration of the validity of the marriage first, right? As is usually the case. And it appears that the Recognition of Customary Marriages Act, Section 3, the requirements are met. As in the age of the parties, they are above 18. The marriage has been consented to, and it has been celebrated and entered into in accordance with customary law. All those requirements, in other words, the official requirements have been entered into. But what is in dispute is the living requirements, in other words, the customary law requirements. What are those customary law requirements which are not in the Recognition Act, which are applicable, especially for the communities that are in the bench where you are actually applying to?
Well, one of them would be the handover of the bride, wherein the bride is officially handed over to the family of the husband, and they change also the surname, because until in some communities where the surname is not changed, other people don't take that as a marriage, even though they accept for some who are professionals who may retain their maiden surname or double barrel. So those are some of the not listed elements that are there in terms of customary in our communities.
Thank you, DCJ.
AP Betty?
Thank you, DCJ. Good afternoon, Ms. Mdluli.
Good afternoon.
The question that I have to you has to do with one of your judgments in William de Pella versus the state. And I have a few fundamental problems with that judgment. Your paragraphs 1 and 2 tells us what the charges were and that he was convicted. Then the paragraph 3 says that the appellant is appealing against both conviction and sentence on both counts. And the next sentence, which is contradictory, says the matter is before us on automatic review in terms of Section 309 of the Criminal Procedure Act.
Yes,
Did the matter serve before you on appeal or on automatic review?
It was before us as an appeal. It's actually the matter that the ADJP was referring to where we sat together. So it was an appeal.
Thank you. Then for the most part, your judgment traverses the evidence, and ultimately you conclude that the state had failed to prove its case beyond reasonable doubt on count 1, which was rape, but that the conviction on count 2, which was assault, was unassailable.
Correct.
But what I find puzzling is that then in your final paragraph, the order, of course, upholds the conviction in relation to the count of rape, set aside the sentence. Then paragraph 2 confirms the conviction on count 2. Then you set aside the sentence of 3 years that had been imposed by the trial court. And there's nothing in the text of the judgment to indicate how you came to the conclusion that the sentence failed to be set aside. Are you in a position to comment on that aspect before I proceed to the next?
Yes, as I look at the judgment, Commissioner, you are correct that I have not said anything with regard to my increment of the sentence therein. However, the reason why...
I'm sorry to interrupt you. I'm not there yet.
Okay.
You set aside the sentence.
Correct.
But the judgment itself doesn't tell the reader what you took into account to arrive at that conclusion.
From my brief look at this, I don't see it at the moment. You're correct.
Okay, let's proceed. Then the other fundamental difficulty I have, the trial court had imposed a sentence of 3 years, which you set aside, and increased, then you increased the sentence to 5 years.
Correct.
and you say nothing about whether the appellant had been forewarned or whether there had been an appeal by the state, because there are judgments of our court which says that the appellate court, it is not competent for the appellate court to increase a sentence when there is no appeal by the state against the sentence. There's one which I wrote at the SCA 2015-16, which was confirmed by the Con Court a year or two later. Do you have any response to that?
Correct, Acting President. When I increased the sentence at the time, I took into account the gravity of the assault GBH that was perpetrated against the complainant in the matter.
But you accept that there was no appeal
Yes, I
by
do
the
accept.
state against the sentence?
I do accept that there was no basis for that laid in my judgment, Commissioner.
Thank you. Thank you.
Could I
Chief
just follow
Justice.
up on this question? Because I actually noted that judgment. But my understanding is that you were actually sitting with a senior judge who's the president of the division in that very case.
Correct.
Commissioner Nyambi?
DCJ, thank you. My colleagues have done justice, so it won't do any harm for me to say I'm ready, I'm covered for the next candidate.
You won't follow suit?
DCJ, since I'm instructed, I will follow suit.
I'm not instructing you to do anything, please. All right, any further questions, colleagues? Any questions from the virtual platform? No. All right. We have reached the end of your interview, Mr. Mtloli. Thank you very much for making yourself available. I wish you all the best. You're excused.
Thank you for the opportunity and for the hearing. Thank you.
DCJ, can you hear me?
Yes, I can hear you, Mr. Bernard.
I have a question. It just seemed that you could hear us was here. Oh, I can't hear you.
The candidate is already leaving the room, Mr. Bernard. I did call for questions and you were sleeping on the job, it seems.
No, DCJ, I said I have a question a couple of times. My hand has been up for a long time already.
I'm sorry. No, you've missed the boat, unfortunately, Commissioner Bernard. Ngizamnika i-chance yokubuza. lunch, but the presumption was that we would have interviewed all the candidates from Limpopo. So I beseech you to please, can we finish with this round and interview the next candidate, and then break off for a short lunch and come back for deliberations? All right. Be strict now. Good afternoon, Ms. Mtimkulu.
Good afternoon, DCJ.
Are you ready?
Yes, I am.
All right. You hold a number of academic qualifications.
5 to be exact, DCJ.
Do you want to tell us what those are?
I hold a BA, LLB from the University of Cape Town. I higher diploma in tax law. I higher diploma in international tax law from the University of Johannesburg, and an LLM from a university in the United States.
An LLM in intellectual property law, you should mention that.
Yes, DCJ.
All right. When did you obtain these qualifications?
I obtained my BA in 1991, my LLB in 1995, my higher diploma in tax law in 2010, my higher diploma in international tax law in 2011, and my LLM in 2014.
And you, well, the last three you did while you were working, or you were already on the job market.
That is correct, DCJ.
Where did you find the time?
I had to stretch myself, DCJ. In a 24-hour day, I had to do a lot of my work as well as my studying.
So after you did your articles with the Legal Aid Board, you worked for the Road Accident Fund as a claims handler and didn't spend a long time there. You opened your own, you started your own practice.
That is correct, DCJ.
How long did you run your own practice?
I ran my practice for approximately a year
And then went back to the Legal Aid Board.
and went back to the Legal Aid Board.
But you didn't stay long there either. You left and went to the NPA.
That is correct, DCJ.
And from the NPA, you became a magistrate. That was in 2002.
That is correct.
And that's where you've been. You've been working your way up the ranks, I see.
That is
today.
correct, DCJ.
All right. So you started as a district magistrate, and that was quite a longish spell. For what, 8 years?
I was in the district court for 8 years.
And then became a regional magistrate.
I became a regional magistrate in 2010.
Yeah, but then you went, did you go back to the district court? I'm a bit confused. What happened between 2015 and 2019?
DCJ, my story is, or rather my route is a bit of a unique one. I was appointed a regional magistrate in 2010, and I resigned in 2013 because I was offered an opportunity to go and study in the USA. I got offered a scholarship by the University of New Hampshire School of Law to do an LLM in IP law. And when that offer came about, I approached my regional court president then, as well as the Magistrates Commission, to see if I could be granted sabbatical leave for me to go and study in the US. And I was advised by both my regional court president as well as the Magistrates Commission that if they were to agree to my request, it would set a bad precedent, and they refused the sabbatical leave. I then decided to resign because I thought it was an opportunity of a lifetime and I could not let go of it.
So when you came back, you had to start at the district court?
When I came back, I had to start in the district court again.
But then you found your way back to the regional court?
That is correct, DCJ.
All right. Your first acting stint was in mid-2021.
That is correct, the third term of 2021.
Yes, and you've acted intermittently until December 2022.
I have actually acted up until the 24th of March 2023. That is not indicated in my CV because of the time when I had submitted my application. But I was in the High Court in the first term of this year.
All right. In which division have you acted?
I have acted in the Gauteng division of the High Court as well as in the Limpopo division of the High Court.
And
However, DCJ, in the Limpopo division, I've only acted for a period of 5 weeks.
Is that where you've acted in 2023?
That is correct.
I see. And so what is the cumulative, what's the total of your acting stints?
If my calculation is correct, and I am subject to correction, it is about 45 weeks.
45 weeks, all right. Which meets JP Mlambo's standard of 28 weeks. It far surpasses it. Just pulling your leg, JP Mlambo. Have you had an opportunity to pen any judgments during your acting stints? And if so, how many?
I've had the opportunity to pen judgments during my acting stints, and I have penned at least 16 or 17 judgments.
Okay. I see from your CV that you sat both in the criminal and civil courts.
I have sat in both. Well, in Gauteng, I've only sat in the criminal courts. However, when I was approached by the Limpopo division, well, the JP in Limpopo, I was offered an opportunity to sit in the civil court and in motion proceedings.
So your first experience in the civil court has been in 2023, in these 5 weeks you mentioned?
That is correct, DCJ. That's notwithstanding the, the other civil work that I've done in both the district court and the regional courts.
Of course.
Yes.
All right. Do you have any reserve judgments in the High Court? Well, both in the High Court and in the regional court?
In the regional court, I do not have any reserve judgments. I do, however, have reserve judgments in the Limpopo division of the High Court because it's not long that I have left.
Those would be new.
Those
were
would be
fresh.
new, yes.
Mhm. Do you have any part heads from the regional court?
I have in the regional court to date about 6 part-head matters. And in all those matters, the accused persons are out on bail.
All right.
In the regional, that's in the regional court. In the Gauteng division of the High Court, that is in Johannesburg, I also have a part-head matter that we started in 2022. And it is one lengthy one. It involves 5 accused persons who are all in custody, and I think they're facing about 62 counts in that matter.
All right.
And it had about 124 witnesses. We've dealt with about 68 of those witnesses.
Yeah, it's one of those monster cases. All right. Okay, I'll leave it at this point for now and hand over to the other commissioners to put questions to you if they have any. AJP?
Thank you, DCJ. Have you ever been in Thohoyandou in your life?
We can't hear you at all.
Have you ever been in Thohoyandou in your life?
I have never been in
You have never
Thohoyandou.
been. You don't even have a clue of where the court is.
I don't even have a clue of where
Still
the court
can't hear
is.
you, AJP. I'm
Yo.
sorry. Just turn it around so that you speak directly into it.
Okay. You say you don't even have a clue of where the High Court is and whether you will be, you will be comfortable with working at Thohoyandou. You don't know.
I don't think it would be a problem, and I'll tell you why, acting JP. I have worked in a lot of courts. When I was appointed in the regional court, I was appointed a regional magistrate in Klerksdorp. And it wasn't with difficulty that I fitted into that court. So as long as Thohoyandou is in South Africa, I don't think it would be a problem.
Thank you. I have worked with you for quite a short period of time, and also the judges in Limpopo worked with you for quite a short period of time, but all I can say is that I never even had any complaint about you from either the practitioners or the, sorry about that, from either the practitioners or the colleagues, and I cannot say much further about this.
Thank you, Acting Judge President. I'm one of those people, wherever I go, I try and be collegial to everybody that I work with. So if you had any complaints, I would be surprised. It's not in my nature to ruffle feathers, so I think this is why you haven't had any complaints. Thank you.
I have no further questions, thank you.
Thank you, DCJ. Mr. Mtunkulu, good afternoon.
Good afternoon, Commissioner.
I've asked all the candidates the same question on traditional leadership. It's a very strong institution in Limpopo province. I understand you may be coming from Gauteng and other places that, well, the last I remember, Gauteng had only 2 traditional leaders. In Limpopo, we have almost 200. So traditional leadership litigation forms a fair amount of the court workload. Have you had any experience in traditional leadership, either as a practitioner? Sorry, you didn't practice. Have you had any experience in traditional leadership as a presiding?
I think having presided in Gauteng largely and having practiced in Gauteng, I haven't had any. However, when I got to Limpopo and I was faced with situations where I had to deliberate or adjudicate on those matters, I've always approached the senior judges just for guidance and also read up on those issues.
Okay, thanks. And then I just want to refer you to a comment made by the Limpopo Law Society at point 28.4, where they say that appointing you will not send a wrong message, though she still needs to learn on other fields of law as she is more experienced in criminal law than other fields of law. And keeping in mind with your lack of experience on traditional leadership matters, how would you comment on that?
I think they have their own opinion of what it is needed of me, and I wouldn't say it's right or wrong. If that's their view, then so be it. But I think I am capable, and I've always said when I am faced with a matter or something in the law that I feel uneasy about, I always consult. I always speak to other judges to find out more about the subject matter. I'm not shy of asking and acquitting myself before I decide on matters. So even if I was faced with a matter wherein I wasn't sure, I would consult and find out or read more about or research more about. As judicial officers, I think nobody can sit here and say, I know it all. So I will ask if it's something that I'm not sure about.
Thank you. Thank you, DCJ.
Commissioner, AP person.
Thank you, DCJ. Good afternoon, Ms. Mtunkulu.
Good afternoon, Commissioner.
Just 2 questions from my side. What does Kruger versus Kutsi tell us about the proper approach to establishing negligence for purposes of liability in intellectual claims?
Having not done any intellectual claims in a while, I'm not in a position to can answer you. And if I were to try, I would just bluff. So I would have to have a look at it.
Well, the test for establishing negligence for purposes of liability in an intellectual claim, forget about Kruger versus Kutsi. What would a plaintiff need to establish before liability on the basis of negligence may ensue?
I'm trying hard to think. I can't think at this point in time.
Thank you.
I'm not sure whether it would be culpa, but would have to have a look at it, I am afraid.
Thank you. Then the second and last question. When you sit as a member of an appellate court in an appeal against sentence, generally without reference to the Minimum Sentences Act, under what circumstances would an appellate court be justified in interfering with the sentence imposed by the trial court?
If you are of the view that the trial court, or rather that the interest of justice were not served by the trial court in the passing of sentence, and having balanced the personal circumstances of the accused, the offense committed, as well as the interest of society, you feel that there was a misdirection in the passing of sentence.
Thank you.
Thank you,
Thank
AP.
you, DCJ.
Commissioner Nyambi.
Thank you, DCJ. Afternoon, Ms. Mtimukulu.
Good afternoon, Commissioner Nyambi.
So that I don't become unfair when we're doing deliberations in a closed session. Sitting there, you are a candidate that has never been to Thohoyandou. Probably you are applying to go to a place that you don't know. I don't want to have wrong assumption. Maybe if you can explain the reason why you never thought it's necessary for you to understand the place you'll be going to. Is the issue of the division of Thohoyandou. She said she has never been to Thohoyandou. So for me, when doing deliberations, because sitting there is a person who has never been to Thohoyandou, probably if you can share the reason why you have never bothered yourself to understand the place you are going to, so that we are comfortable that you'll stay there. It's not a person that after appointment won't be comfortable because you'll be seeing the place for the first time.
Thank you, Commissioner Nyambi. My not going to Thohoyandou, it was not because I was not interested in going. I think because of work commitments at the Polokwane court, I did not have the opportunity. It had been planned that I would go and visit the place and familiarize myself with the court there in the week, on the day of the public holiday in March, because I was already closer to Thohoyandou. But on the 21st of March, or in that week, I was seized with presiding over urgent applications, and there was a matter wherein I had to preside over, and that matter took preference, and I could not get away from that matter and had to deal with the matter on the 21st of March 2023. But it had been my wish to go to Thohoyandou. But also in that week, we also had the national shutdown, and we were advised that we should try and not be on the roads.
Share with us your understanding of the doctrine of separation of powers.
Okay, the doctrine of separation of powers is a constitutional doctrine of our law, and it dictates that or rather it is proclaimed in our constitution that there shall be a doctrine of separation of powers, that it would be the legislature, the executive, as well as the judiciary. And this is to prevent one body having an autonomy on the different functions. So the legislature would be the lawmaking body, the executive would be the body that executes the laws, and the judiciary would be the one that sits and deliberates on legal disputes.
Thank you, DCJ.
Thanks, Commissioner. Deputy Minister?
Thanks. Good afternoon, Ms. Mtumkulu.
Good afternoon, Commissioner or Deputy.
Yeah. What you did a Master of Laws in at University of New Hampshire. What was it in?
It was in intellectual property.
Intellectual property. Okay. And on your questionnaire, there's a question: what proportion of your litigation work has been in the field of criminal law? And you said 90%. Was that when you were in practice, or is that your work in the district and regional courts?
Both in practice as well as in the district and regional courts. I think if you look at my CV, I worked or served my articles with the Legal Aid Board, and the major or the majority of work or the bulk of the work in the Legal Aid Board was to represent indigent accused persons in the criminal courts. So, and when I was in the district court, I was in both the criminal and the civil courts, as well as in the regional courts.
You've sat on civil matters in the regional court.
I actually sit on civil matters in the regional court as we speak. The majority of civil work in the regional court in Soweto is actually done by me. I sit in the civil courts in Soweto, in Protea Magistrates Court.
So since you came back as a regional magistrate, which was 4 years ago, what percentage of your time has been in the regional civil or the regional court as a civil court?
I actually do civil work every day. We have a unique setup in Protea. Initially, when I had started, I was the only one that dealt with civil work in Protea, and I would do divorces if there was a trial, or the motion court roll on a Friday. But when our civil started picking up and a lot of matters were referred from Johannesburg Magistrates Court to Protea Magistrates Court, we found that we had a lot of matters that came from Johannesburg, and I was asked to do these matters or deal with these matters on a daily basis. So on a daily basis, I would sit with both the criminal role as well as the civil role.
Okay, thanks very much.
CJ, I wanted to make a follow-up earlier about Thohoyandou. When were you shortlisted? When were you told that you are shortlisted?
Around, I would have to think hard about it.
Somewhere in January.
February.
The shortlisting happened in January, maybe perhaps you were informed early February, like first week of February or so. What is the distance? Because seated here, we've got Jolas from Eastern Cape. They may not have an idea like you, what is Thohoyandou. So, the distance between Polokwane and Thohoyandou, how many minutes or hours do you drive to Thohoyandou from Polokwane?
I stand corrected, Commissioner Malema, but I think it would be about 3 hours.
No, it's not 3 hours. It's less than that. So let's say it's 3 hours. You get told in February that you are shortlisted for Thohoyandou. For what it takes, you don't spend some hours with all this business. Because you can't say to me from January until now, you have never been to a social gathering or anything of that sort. Here is an area of interest. You don't allocate some few hours to go and check what is this place to show interest. So that indeed, when you come here, you are like, I'm very comfortable with the place. I'm not just going there for the sake of getting into this thing. The next interviews, I'm back here applying to go to a different place. Just an allocation of some few hours to go to Thohoyandou in and out, and then say to us, I'm comfortable with what you are giving me, because we are going to give you something you don't know.
Commissioner Malema, I think the fault is on my part, but when I was told I'm shortlisted, I was already acting in the Gauteng High Court and my transition from criminal to civil for the Limpopo division came as a bit of a shock in terms of the amount of work that I needed to do. I was allocated a lot of opposed motions. I had a lot of appeals that I had to preside over with very thick bundles, and I spent most of my weekends buried in those files, as it were. So it's not like I did not go to Thohoyandou because I was attending some social gathering, but it was just I needed to familiarize myself with the matters that I was allocated in the Limpopo division of the High Court and be well acquitted by the time I get there.
On a lighter note, DCJ, every election in South Africa, I make sure to make a tenant union building myself, because that's where I'm going.
JP Mlambo. Just for that, you will not get a turn to ask questions again.
DCJ.
Thank you very much,
I think
DCJ.
there'll be many of those turns.
Good afternoon, or good afternoon, Ms. Mtimkulu.
Good afternoon, JP Mlambo.
Just two questions. One relates to the reserve judgment you reflected on the 28th of September. Has it been handed down, and if so, when?
The judgment of that is on there was handed down on the 13th of December 2021.
This state versus Magengenene.
Oh, sorry, 2022. 13 December 2022, State versus Magengenene.
Thank you very much.
The matter, yes.
Now, the other matter you reflect as apartheid, I think just your probably deals with your philosophy as well as a judicial officer regarding access to justice. Is this the matter that you say has many counts and it remains apartheid?
That is correct, JP.
It's a Gauteng matter.
It is a Gauteng matter.
I have a number of these matters in Gauteng, and parties, especially the presiding judges, make a point of being tough on practitioners to make sure they open up time. What is preventing this matter from getting to finality?
JP, that matter we have set, and we have listened to evidence in that matter. The council are always there. I think when you were away in the Constitutional Court, we were also given a term and we ran with the matter. And witnesses were subpoenaed. We've listened to that matter or dealt with that matter each time it's been set down. So it's not as if there has been any truant from either the state advocate or the defense counsel in that matter. It's just the complexity of the matter, and some of the witnesses in that matter, JP, are coming from KZN, and each time witnesses subpoenaed or called to come and testify, we sit a full day in the matter.
Well, I wasn't suggesting truancy on anyone.
No, I'm just saying,
saying-
JP, that we have dealt with it. If you can see the files in the matter, you will see the progress we have done in the matter.
Yeah. Is this the matter where you say the accused are on bail?
No, all 5 accused are in custody because some of them have been convicted in other courts and are serving sentences.
Okay. I think from an access point of view, just my comment, nothing prevents yourself from getting long-term commitments from counsel and state advocates in the matter and get given time, 2 terms at a stretch, to make sure that this matter finishes. Thank you, DCJ.
I will remember that, JP. Prof?
Thank you very much, DCJ. Good afternoon, Magistrate.
Good afternoon, Commissioner.
I have a question for you in relation to criminal law generally. But I will start by saying there are concepts in law which, from time to time, we see that they become even more difficult to explain, like your good cause shown, and the one that I'm going to ask you about now, exceptional circumstances. And my question to you is, when one looks at Schedule 6 of the Criminal Procedure Act, that deals with bail applications in terms of that section, and it requires this particular requirement, exceptional circumstances. In your view, what constitutes exceptional circumstances? Because it appears that this is something that is used either to grant or to deny bail without really explaining. No, the interest of justice, there are no exceptional circumstances, bail is denied. So how should this particular concept be understood so that we can get some sense of consistency in the manner in which bail applications are dealt with in terms of Schedule 6?
Thank you, Commissioner, for that question. Exceptional circumstances has not been defined, but I would suppose that when we deal with phrases or, like in this instance, exceptional circumstances, phrases that have not been defined, the starting point would be to give a grammatical meaning to the words and try and see if there's anything that's exceptional. I've heard people, well, when they address you, they would be like, if the applicant in a bail application does not prove or does not show that if bail is not granted or bail is granted, the sky will fall, then there's no exceptional circumstances. But it would be to give a grammatical meaning to the words that are before us, or to the phrases, I suppose. But that having been said, exceptional circumstances have not been defined, and you would also maybe look at the merits or the circumstances that you are dealing with at that point in time to determine whether there is exceptional circumstances or not.
All right. My final question is in relation to the Section 302 automatic reviews that normally come from particularly district courts, and I understand that perhaps maybe you are at the regional court. When you look at some of the decisions all across the divisions of the High Court in different provinces, most of the judges are complaining about the quality of the responses when queries are made to the magistrates. But not only that, the delays that are actually occasioned by such replies. And they delay, but they are inadequate when they are actually provided to the judges. What causes this? Because sometimes you find that in these reviews, the accused persons are actually in prison. What causes these delays, and how can this issue be addressed so that we can ensure that justice prevails?
I think from where I come from, these delays are usually caused by the support staff. Because, say in the appeals office, for instance, or the clerks that have to, when they receive these like application for automatic review or whatever the case may be, if they're not well trained and do not know the time periods or the urgency that they have to act on when these land on their desks, it becomes a problem. So if the court support staff or the clerks that have to assist the magistrates in, say, giving reasons, for instance, are not trained, we will never see the light of day. It would always be a problem with the delays.
So we are going to blame them also on the quality of the replies. But anyway, I will leave it there. I will leave it there, DCJ.
I'm not, I'm sorry, I didn't get the quality of the reply. I think also maybe at Sajay, those are things that should be taught. Because I find when we go to these trainings, there's things that they don't give as much training on, because they maybe assume that everybody knows how to handle these.
It's fine, I will leave it there, DCJ.
Thank you.
Commissioner Dodov?
Thank you once more, Deputy CJ. Ms. Mtimkulu, I can see that you have a lot of educational qualifications. Now, I want to draw you to these qualifications. 2009, you completed a higher diploma in tax law.
That is correct.
2010, diploma in international taxation. And 2014, you went to the US and studied a master's in intellectual property law. And looking at what you were doing as an attorney, you spent 90% of your time on criminal law. Can I assume that all of these are in vain? Because where you are applying to, there are no areas of tax law like they are where you are moving from. In Johannesburg, in Gauteng, that is where tax issues are. That is where international tax issues are. That is where intellectual property issues are. And you want to go to Toyando. What exactly drives you to want to go to Toyando and leave an area where you can best apply and proliferate what you have learned at different institutions of higher learning?
Thank you for that question, Commissioner. I think when I went to varsity and got these qualifications, my plan, or rather my thinking was that one day I would be able to use these qualifications. But when it comes to issues of where one applies and where one gets shortlisted, unfortunately, it's not something that I have a say on. I can apply to a division maybe that wherein I can use these qualifications, but if I do not get shortlisted in that division, it's not something that can be blamed on me. When I pursued a higher diploma in tax law and a higher diploma in international tax law and did a master's in IP law, I wanted to have these qualifications so that when one day I present myself before the JSC, I can say, this is what I've done.
Yes, but you are not practicing them. And I put it to you that where you want to go to, these things are quite limited. And on that score, have you made a research about the court where you want to go to? What kind of cases?
Yes,
the nature of cases and what? Because I would argue that this is very, very lean.
I have made my research. Unfortunately, that's where I am shortlisted.
Or you just want to be the judge more than any other thing else because you applied to be a judge and your application was considered and that you are shortlisted to Limpopo. Are you saying to this commission, all you want to do is to be knighted as a judge?
Not necessarily, sir. That's a incorrect
That's the impression
assumption.
that I'm getting for you, that you applied and you got shortlisted. And in this particular instance, you are shortlisted to Limpopo in Thohoyandou. And I'm saying, I'm looking at this and I know the area. That area service Matumbiza, Musina, Makado, Thohoyandou, and all of those. Those are villages. I'm sitting here thinking, I don't think of any intellectual property matter that can come before to the attention of a lawyer or a court in that the only, if there would be a struggle, it will be about black leopards more than anything else.
I hear you, sir, but you may be surprised that there is maybe one IP matter and I'm better suited to can deal with it in that,
all
that
right.
area.
Okay, no, it's okay. I'll deliberate. Thank you very much.
Thanks. Just a quick follow-up from Commissioner Dodovu's question. If you got appointed, how long would you plan to stay at Thohoyandou for? Or when would you start applying, when would you start applying for other posts? But can you give us a commitment if you're appointed, I'll be here for 5 years before I apply again, or you're not in a position to do so?
I'm not in a position to do so because I do not want to be, I do not want to limit myself. I might want to apply, if I am recommended and I feel I'm ready to apply to the SCA, I do not want to be told, but you said you want to stay in Thohoyandou for 10 years or 15 or 20 for that matter. Because there's other options that might come up should I be recommended.
Okay, but I think the concern from many commissioners is, and I think it was what Commissioner Malema had said, that you would get, if you get appointed, will the next round of JSC interviews see you applying for other high court posts? That's a concern. So I'm giving you the opportunity to persuade us otherwise.
I will stay in Thohoyandou. As long as it's feasible and I will stay in Thohoyandou.
But you don't know if it's feasible because you've never been there.
Can I just make a short follow-up to Commissioner Dodovu's question? Mr. Dodovu says that you will not get IP law in Thohoyandou. You may not get it, but you say, well, perhaps you may. But I want to ask you about something you may actually get in Thohoyandou, which is customary law. So if you have a dispute on a rule of custom, Party A says the rule is X, Party B says the rule is Y. How do you approach the resolution of that rule, and what are the leading authorities from the Constitutional Court and Supreme Court of Appeal that will guide you?
I do not have an answer for you, Advocate Ngwaitobi.
Thank you, Deputy Chief Justice.
DCJ, if I may just follow up with the Minister and Commissioner Dodovu's question. Good afternoon, Ms. Mtunkulu.
Good afternoon, Commissioner Pillay.
I have a separate question that I'll ask you in due course, but I was very concerned by an answer that you gave in response to a question by Commissioner Dodovu, And I'm really hoping that I heard you incorrectly. So I need to, in fairness to you, I need to give you an opportunity to deal with it. I thought that you said that unfortunately that's where I was shortlisted in reference to the Toyando court. It's a very concerning statement, and I really would like to give you an opportunity to address that.
It might have come out wrong, Commissioner Pillay. Rather, fortunately, that is where I was shortlisted, because I had applied to the Limpopo Division of the High Court, that is Polokwane as well as Toyando. I put in that application. And I also applied in the Northwest, and I was shortlisted in Toyando. I applied for Toyando. So it's fortunate, it's just probably came out incorrectly.
Thank you, DCJ. Is it my turn? Thank you. I just have one question, and the question is really designed to probe your judicial philosophy. So can I ask you, and I really want to ask the question in relation to your Muzwakali judgment. I think it's the last judgment included in the pack. Do you recall that judgment?
Yes, I do.
It's an appellant who appeared before you, and he was appealing against both conviction and sentence. And he was convicted of raping a 6-year-old little girl. Do you recall the matter?
Yes, I do.
And you considered the appeal against conviction, and you confirmed the conviction. In other words, you found that he had raped the little girl.
That is correct.
Then when it comes to sentence, you had to consider whether or not there were substantial and compelling reasons to depart. Do you remember that?
That is correct.
And I want to read to you, because I don't want to do you a disservice, I want to read to you what you say about substantial and compelling circumstances. You refer to the evidence of the doctor, and you say, the doctor further elaborated in his evidence that the blunt object that caused the attempted penetration could have been anything ranging from a penis, a finger, or a foreign object. He further conceded that if a lot of force was used, the object was pushed in very hard. The severity or extent of the injuries would be apparent. However, if the object was inserted gently, the result is that one would get less severe laceration. Then you say the conclusion of the doctor is that the degree or extent of the injuries suffered are less severe compared to a person who was fully penetrated. And you say, I therefore regard the findings of the doctor as substantial and compelling circumstances, justifying a deviation from the sentence imposed by the magistrate. Now, do you still stand by this finding that if you have penetration that is gentle, or if you have penetration that is not full, and the victim, as in this case, is a 6-year-old little girl, that you consider that in itself to be substantial and compelling reasons to depart from the prescribed minimum sentence?
Okay, I have had a long thought about this judgment, and you correctly point out it was an appeal judgment. I have to disclose that in this appeal, it was a full bench appeal. I had written 2 judgments, but the senior judge that I sat with was of the view that that because this is what the doctor's findings were, that the initial judgment that I had written would not stand, and so I was conflicted and probably swayed by the senior judge.
So, Mr. Mkulu, I really don't want to cross-examine you, but I'm afraid your answer makes the whole thing worse. Because it now seems that you don't agree with the judgment that you included in the pack. And secondly, that the judgment doesn't reflect your honest views on the matter.
I think it does reflect my views on the matter, but we were a bit, there were, there was a bit of power struggle as to the conclusion that we got to.
Follow up, say.
My own follow-up first. Are you suggesting that you allow the senior colleague to dictate their view on you?
I was swayed by the senior judge.
Were you persuaded?
Persuaded, yes.
That he or she was right?
Yes, because it had been said, or rather the doctor's findings were not certain as to what had caused the injury on the complainant. It could have been either a finger, a penis, or a blunt object. There was no, it wasn't decisive.
So you were persuaded that the senior colleague is correct?
That is
in their
correct.
view? Okay.
Now, DCJ, on your point, so just a quick one. We are now abandoning the point you raised that there was a power struggle. Because persuading and power struggle are two different things. You must choose your struggle. Which one is your answer?
I was swayed, Commissioner Malema.
So the power struggle is off now?
Yes.
Okay.
No, I'm covered. I'm fine.
Thank you, DCJ. Good afternoon, Ma'am Timkulu.
Good afternoon, Commissioner.
Just one clarification question from myself that stems from the answer that you gave when you responded to the question on the separation of powers. Did I hear you correctly to say that in the Constitution there is a clause that says there shall be three arms of government? And two, isn't it correct that in the Constitution there is no clause specifically that says there shall be three arms of government, but rather what we have, you will have chapter 4 that talks to the working of Parliament, and that in chapter 5 of the Constitution you will have the working of the executive, and in chapter 8 you'll have a chapter that specifically talks to the work of the judiciary. Is that not your understanding? Thank you, DCJ.
I think there is a proclamation. I might not have the Constitution before me, but there is in the Constitution a proclamation that there shall be three arms of the government, or three arms being the legislature, the executive, and the judiciary.
Thank you, Ma'am Timkulu. Thank you, DCJ.
Thank you, Deputy CJ. Good day, Ms. Mtimkulu.
Good day, Commissioner.
You know, mine is quite different. I just wanted, you spoke about training, so that some of the training, it doesn't equip one with some of the, the tools of being able to do certain things. My question to you is it's not a question, I just want to hear your opinion. Do you think that the regulator or the Bar Council, we should introduce continuous legal training, even if we have qualified as an attorney or an advocate? Because for me, I think we seem to think once people have qualified, they can swim on their own. Do you think so?
I think not only in the Bar Council, throughout, be it in the judiciary, the magistracy, attorneys, advocates, training should be something that we strive, there should be continuous training. It doesn't matter where you sit. It is important just for us to be sure that we are on the same page when we deal with the administration of justice.
Just a follow-up, do you think, what I'm trying to find out is that should we compel you to do continuous legal training and for like other professions, or do we leave it to the discretion of the candidate that, you know, for instance, judgment writing, you know?
Can you please repeat your question, ma'am?
I'm just saying, I'm thinking, do we think we should compel qualified attorneys and advocates to undergo continuous legal training on other matters that they haven't learned? Or we leave it to their discretion to do it?
It is a tricky one, but I think maybe compelling would be the way to go, Commissioner.
I'm not entirely sure what's going on, but it does appear that our recording operations are still okay. Can I just find out if the colleagues on the virtual platform are still connected? Commissioner Bernard, are you there? Commissioner Breitenbach? We may have lost them. Can someone tell us what's going on? Who's responsible for? Yeah, it's still on. Okay, well, I'm told it's probably load shedding, and it usually takes about 5 minutes for the generator to switch to kick in. Okay. All right. We have a report. Our commissioners on the virtual platform are connected, but they're trying to get the sound back. So we should just wait a little bit. We're almost done, colleagues.
Thank you, TCJ. Good afternoon, Acting Justice.
Good afternoon, Commissioner.
Acting Justice, I would be unfair to you if I don't ask you this question. In fact, I want a comment. It flows directly from the debate we had with Commissioner Pillay and the DCJ about the judgment. First, do you say you wrote 2 judgments? One which says there were no exceptional circumstances, and then one says there were compelling reasons that
been established. What is it when you say there were
Oh,
two judgments?
well, the initial judgment that I had wrote, we had to deliberate on, and I was swayed by the senior judge, and we came to the conclusion that we came to in the judgment that I penned, and the conclusion that I came to. So it wasn't two separate judgments.
My problem is this, I just want to put that, is that to me, your answers you give to this very important question, that you are not an independent person. If you think you are, you lack backbone, you lack backbone, you know, and those are qualities that go for a judge. Because I'm saying this, I want you to comment, because you have accepted, once you are persuaded, you have accepted, it becomes your judgment. Now when Commissioner Pillay is asking you about that, do you stand by this finding? You say, no, I'm running away. It was what the senior judge was. It means as you sit there, you don't know what was your judgment.
It may not have come out correctly, Commissioner Okyesi. What I was intimating at was that I was swayed by the senior judge upon deliberation, and I took the advice that was given to me by the senior judge.
Thank you.
It may not have come out correctly.
Thank you, DCJ.
Well, if it helps, acting judge, JP Mlambo and I were just reminding each other just now how a similar event occurred to us years back when we were still junior at the SCA in the case of Shilubana, where we were persuaded, but we were persuaded. We were persuaded by senior colleagues much against what we thought was a very stern position, and that judgment ended up being overturned in the Constitutional Court, and our original view being, being the judgment of the day. So it does happen to the best of us. Don't feel bad.
Thank you, DCJ.
DCJ, just a follow-up.
Yes, Commissioner Konish.
Good afternoon, Judge.
Um,
Acting Judge.
Good afternoon, Commissioner.
But when you had a conversation with Acting Judge President, you said you don't like to wreck the boat. And it was when she was complimenting you that everybody likes you. You said you would be surprised if there was no one who did not, because it is in your nature, you just don't like to wreck the boat. Is that not consistent with what you are just saying now?
It's not. What I meant is I'm collegial when I work with people. That's all that I was intimating at. I respect everybody that I work with, and that's in my nature. If it came out incorrectly, I apologize, but I'm just collegial with colleagues in general.
No, it's not something bad. I think it's something good, but I'm linking it with what Commissioner Chase has just been raising now. I'm saying it's not something bad, but I'm linking it with what Commissioner Chase has been raising it now, the ease with which you were swayed.
I take that's how it's understood.
Thank you, TCJ.
Any more questions? Oh, there is a follow-up that's been idling for a while from JP Mlambo.
Thank you very much, DCJ. Ms. Mtimkula, I just want to go back to that question when you are asked to say you only applied to Thohoyandou. I want to understand your answer. You say you applied to Thohoyandou and Polokwane.
Yes, and
Northwest.
Northwest, yes.
And Northwest.
Yes.
Okay. I just wanted to confirm that. And but this year was not the first time you applied, am I correct?
That is correct, JP.
In 2021, you also applied to 2 divisions.
How many divisions?
2 divisions.
Yes,
Is
that's
it
correct.
2 or more?
It was 2.
Thank you. Thank you, DCJ.
Any questions from the virtual platform? Mr. Barnard?
DCJ, but thank you for the opportunity.
All right. Ms. Mtimkulu, this is the end of your interview. Thank you for making yourself available for this interview.
Thank you, the DCJ, for the opportunity, and thank you to the JSC for giving me this opportunity to present myself to the JSC.
Okay, you're excused. Go
Thank,
well.
thank you, and have a good day.
Thank you. Lunch, colleagues, the time is, what's the time? 2:10. How have you been doing it in the past day? 40 minutes? Where does that take us? 10 to, well, I said let's deliberate. It should not take all that long, but I have pressure to break for lunch. Colleagues, what do you say? Should you not deliberate and be done with Limpopo? Good. Okay, let's do that. Can we please clear the room? Good afternoon, Ms. Matlangu.
Good afternoon, Justice Maya.
I'm sorry we kept you waiting. I do apologize most profusely.
Yeah. It was not longer than I thought. I thought it was going to be longer than this.
All right.
Thank you.
You hold 2 law degrees, a BUris and an LLB, both acquired from the Vista University in 1997 and 2001, is that right?
Correct, Justice Maya.
Which Vista University?
Come again, Justice?
Which Vista University?
The Mamelodi one.
Oh, I see.
Yes.
You started your legal career as a prosecutor in 1999.
Correct, Justice
And you
Maya.
remained there until 2003, I see.
Yes, Justice Maya.
Then you became you got a promotion, you became a state advocate,
Yes, Justice Maya.
which you did until 2006. And then you went further up the ranks of that institution, became a senior state advocate until 2012.
Correct, Justice Maya. And then in the midst of everything, I also acted as a deputy director for the asset forfeiture unit.
When was that?
Uh,
During that period?
Yes, between 2010, I think, and 2012 early. Yes.
You decided to join the bar and you joined the Johannesburg bar.
Yeah, I correct, Justice
But you
Maya.
had been admitted in 2002 already, though.
Yes, yes.
Right. How long were you with the Joburg bar?
This is my 11th year.
Oh, I see. It says here you joined the Polokwane Society of Advocates. Is that an associate arrangement?
Yes, in 2014-15, when it was formed, the Polokwane Bar, yes, I joined them.
Okay. You have acted as a judge a few times in the Northwest Division.
Yeah, correct, Justice Maya.
You started in July 2020 and your last acting stint was in October last year, right?
Correct, Justice Maya, yes.
So how long were these stints in all? What is the total period?
It was 1 term in 2020, 2 terms 2021, and 3 terms in 2022. And then I acted 1 term this year at the Free State Division.
When, in 2023?
2023, yes.
Is that where you are now?
Yes, I'm still there. The first term and this term also.
Oh, I see.
Yes.
And I see from your application form that you sat in all the courts.
Yes.
The whole gamut. But I don't see, oh no, there are criminal appeals. Have you sat in civil appeals?
Yes, I did sit in civil appeals also.
Have you written any judgments?
I did, Justice Maya.
Can you tell us how many?
I think there can be more than 90, Justice Maya. Yes.
90?
Yes.
Any of them reported?
None of them has been reported. Judicial starts on exist, it's just softly.
All right. Do you have any part-head matters at this stage? I see you listed quite a few when you completed the form. Are they
Yes,
outstanding?
Yes, Justice Maya, I still have 5.
5.
Yes.
From when?
From the Northwest.
Okay. But I mean, when did they start?
In 2022 early. Yes.
Right. And the reserve judgments you listed in this application form, are they still outstanding?
No, I don't have any reserve judgments.
Okay, they were delivered. Okay. You have also listed companies in which you hold directorships, but you undertake to resign if you are appointed.
Yes, Justice Ma, yes, I undertake. One of the companies, in fact, didn't. It was started in 2019, just before COVID, so nothing happened to it.
All right. No, thank you very much, Ms. Mahlangu.
Thank you.
I'll hand over to the other commissioners to put questions to you. JP Hendricks.
Thank you very much, DCJ. Good afternoon.
Good afternoon, JP.
Judge Mahlangu, how are you?
I'm okay, and you, JP?
Good, can't
Yes,
complain, thank
yes.
you. Thanks for asking. You were interviewed in October last
Yes,
year.
I was here in October
Yeah.
last year.
And just to follow up on the DCJ's question, did you resign from the bar at one stage?
I at the Northwestern Polokwane Bar, yes.
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 When was that?
Last year, I think Northwest Bar, I think it was around July, if I'm not wrong, and Polokwane Bar, it was 2021.
Yeah, but are you currently a member of any bar?
Of the Johannesburg Bar, yes.
Okay. Yes, thank you. I have a few questions that I want to canvass with you. There are comments from the law bodies. I think you are aware of it.
Yes, I'm aware of them, JP.
Yeah, in particular from the GCB. Yeah. If you look at, I think you must have a copy
Yes, I do.
in front of you.
Yes.
If you look from paragraph 8.3 onwards, and any comments?
Regarding this matter here.
No, regarding the comments by the GCB.
Oh, I noted the comments and I went through them. I think they are unfortunate comments and they are defective. They do not stipulate what is correctly said in these matters. I am of a view that, as they have stated at the end there, that I'm a correct candidate to be appointed, and the comment stated, if maybe I may start with the matter that is in 8.3, the matter of the matter mentioned there. I won't mention the name of the matter. Yes, it was a defamation matter.
Okay.
Yes, and in the plea of the defendant was replacing the how. There was a clip that was presented in court on the screen. And in that clip, the defendant clearly stated that they're all wearing the Nehau uniforms. They're all picketing. And then the first sentence he said was, I am here representing Nehau. I'm going to present whatever I'm presenting on behalf of Nehau. And the plaintiff during the trial did admit that indeed the defendant was not saying whatever he was saying in his personal capacity, but in his capacity as the chairperson or chairman of Nehau.
Yes.
Yes.
Yeah, if you go to 11.2, it states there that you display some hostility. You are hostile towards council. And 11.4, the temperament.
Yes, I saw this hostility that was said. Unfortunately, it is not clearly stated what is that, how was I hostile towards council.
Yeah.
Yes, and 11.4, the temper also, like I said last time that JP, I'm a very kind person. I don't see myself being temporal to the practitioners or any other person that appears in my court. I'm fully aware that I'm in court because of the people that appear before me. So I make sure that they all become comfortable and in presenting their cases. I don't know hostile, what do they mean by hostile? Maybe they're intimidated by my voice when I talk. I don't know. I don't understand what they mean by being hostile, but I cannot be hostile in a place where I'm put by the people. I'm there to serve them. So I cannot go there and be hostile towards them, as I am there for them.
Can I move to a different topic?
Yes, you may.
And that is with regard to the parted matters.
Mm.
You say there are still 5 parted matters outstanding.
Yes, yes, yes.
Yeah. You remember that in January there was an incident where you double booked yourself.
Yes, 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 yes.
There was a circuit court in Garankuwa which you arranged a date yourself.
Mm.
And then there was also for the very same week a circuit court in Klerksdorp.
Yes, yes.
Yeah, and we discussed that issue.
Yes.
How was it resolved?
Because I was in Garangua for a week, that matter was postponed, then I went to Klerksdorp to attend to the one that is in Klerksdorp.
Yeah.
Yes.
And remember, I outlined to you the cost implications even for the state. It's not merely about the postponement of the matter, but there's cost implications.
Yes, yes, you did.
Yeah. And you are currently acting in the Free State Division.
Yes, yes, I am.
Yeah. We communicated and you also informed me that there is a criminal matter that you want to postpone because you are not available. And I asked why, because you arranged a date and you said you are going to act in the Free State. You remember?
Yes, yes, I remember.
Yeah, and then I told you, but the litigant, the accused, is going to suffer.
Yes, yes.
Yeah, and now did you arrange that?
And then, JP, if you can remember, you said I must come and do it.
Yes.
I did go, yes, I did come. I did went to Klerksdorp to do it.
Yeah, perhaps you can inform the Commission about the status of these 5 parted matters, seeing that you are now acting in the Free State.
Yes.
When are they going to be finalized?
I've all set them down during recess of June.
How many are criminal matters?
4.
4 criminal
Yes,
matters.
yes.
And the accused, are they in custody or not?
The accused are not in custody. Yes.
Yes.
And JP, if I may say, is the one in Klerksdorp, one of them, the accused are 14. So it's such a very big hurdle to deal with that matter, taking into consideration also the load shedding and everything. I've wished and wanted to finalize them during January as I came back from holiday or from the December holidays far earlier than any other person, so that I can be able to finalize them. Unfortunately, I could not. Even the one in Garankuwa is more than 5 accused, so it's not easy cases to deal with.
And all 5 of these cases are backlog cases now.
Yes, yes, yeah. Yes. The other one, the 5th one is at Hamahikeng. It's a civil one. It's 17 plaintiffs also. And it's the same challenge that I have. Each plaintiff has his own arresting officer, the witness. It's a very, very, very long trial also. So I understand that they are backlog, but it's not like where you have one accused person where you can be able to manage that trial. A trial where it's more than one party, it's very difficult to deal with promptly.
Yes, thank you, DCJ.
Thank you, JP. Premier?
Good afternoon, DCJ. Good afternoon, esteemed members of the JSC. I just want to have one question. If you look at the report of the GCP and you refer to 14.1, how do you reconcile 14.1 with 8.2?
Good morning, good afternoon, Premier. I take note of both 14.1 and 14.2, and I could not understand why in the same breath they say that I should be appointed. and because I have the independent mind, and then in 8.2, they say I don't have enough professional experience as acting judge. If I calculate my acting stints, they go to more than 1.5 years. So I don't know how long do they expect me to come act so that I can have this experience. I think I have enough experience that is needed and enough experience for me to be appointed in this.
That's all I had, Deputy Chief Justice.
Thank you, Premier.
Thank you.
Commissioner Nyambi.
Afternoon, thank you, DCJ. Afternoon, Ms. Mahlangu.
Afternoon, Commissioner Nyambi.
As JP indicated that you were with us last October. So almost all of us here were able to have an opportunity to ask you some questions. It's some 5-6 months ago.
Yes, Commissioner.
So anything significant, because we do have the transcript of October, that you might want to share that might have happened between then and now, so that as this commission this time around we have to seriously consider?
Commissioner Nyambi, after the interviews of last year, I took it upon myself to train myself how to write judgments. And I read and went through the previous judgments of other judges. And I constantly discussed or asked the Deputy Judge President of the Northwest to give me some input and some more training on how I can approach judgments. And that is why when I was requested to come act in the Free State, I took the opportunity, taking into consideration that more training, I'll have more training from acting in that division. I therefore think that based on that, I'm ready, and I've gained more training based on the judgment writing.
My last question, if you reflect about the last interaction with this commission, probably if you can share with us, with hindsight, anything that you might have done when you were doing a reflection in a way that you might want to correct it this time around. I'm referring to the last interview of October.
Yes.
So you have an opportunity now to correct anything that you think might have made you to be at a disadvantage this time around so that we can seriously consider.
Thank you, Commissioner Nyambi. I really don't know the reason why I was not taken last time, but what I can say is there was this matter that, as I said, I could not respond to it because it was on appeal that Commissioner Ngugaitobi asked me about it. And I did not answer to that because I said I don't feel comfortable in that matter. And what I can say is the appeal was finalized and my judgment was upheld. The appeal was dismissed in that matter. So I think I wouldn't really know, Commissioner Nyambi, what is the other thing that made me not to be recommended in the last interview.
No, DCJ, maybe if I can assist Ms. Mahlangu. The question was, you remember what you said last October. So the question was the responses you gave us in October. So you are still of the view that everything that you responded to in October was fine as far as we are concerned, except the one of Advocate Ngoeto, SC.
I think the other question was why you? Why should we consider you? That was asked in the last interview. And then now, if I can answer it now, is that based on the experience that I have, based on the acting stints that I had, and the judgments that I delivered in time, And out of all my judgments, I only received 3 leaves to appeal. 1 was not prosecuted, 2 were prosecuted, but the appeal were dismissed. And the other reason why I think I'm the right person for this position, Commissioner Yamba, I hope I'm still on the right track, was because of the unique experience that I have since I've started as a prosecutor until where I am now. And the other thing that I can say is the question that was asked, why do you think that you're the right candidate for this, is that I worked in the Northwest Province as a public prosecutor. I worked in the Northwest Province when I was working for Asset Forfeiture Unit based in Mafikeng. I was staying there in Mafikeng. So I'm of a view that Northwest Province is calling me to come and serve them now, again, until my retirement time.
Thank you, Ms. Mahlangu. Thank you, DCJ.
AP person?
Thank you, DCJ. It's just a follow-up on the line of questioning by Commissioner Nyambi. Good afternoon, Advocate Mahlangu.
Good afternoon, Commissioner.
You have already confirmed that you were before this commission in October, and I take it that you were provided by the Secretariat with the transcript of your interview.
Yes, Commissioner, I was.
And what I want to put you as a general proposition is that reading that transcript doesn't inspire confidence in your competence for the position to which you aspire. What's your response to that?
It doesn't inspire confidence.
Yes.
As I've said, Commissioner, is that yes, I went through the transcript, and I noted when you say it doesn't inspire confidence, but where I am now, I think I'm confident enough to serve as compared to what I was in last year, October.
But you were here in October, the vacancies were advertised. Hardly 2 months thereafter, you made yourself available for a position in the Northwest.
Yes, I'm sorry to interrupt you. Commissioner, the reason why it made me to reapply is because last year no one was taken. So I thought, now let me use this opportunity again to come here and apply. And based on the experience that I might have got since I've been here in October, and the acting stints that I had, they might increase the experience that I had, that the commissioners might need for me to be able to be appointed.
Thank you, Advocate Mahlangu.
Thank you.
Prof?
Thank you very much, DCJ. Good afternoon, Ms. Mahlangu.
Good afternoon.
I have a question for you in relation to the case that the judgment that you delivered. I think it starts from page 'm. Anyway, I'll get to it now. It is a judgment that dealt with the rescission of the agent application in relation to the Kagisano municipality. You remember that judgment? The municipal manager of the Kagisano municipality, whose contract was terminated. And yes. That judgment. Just that my computer is just frozen here. I'm always curious to understand how judges deal with agent applications. In Gauteng, for instance, there is a judgment that really assists in understanding Rule 612 of the Uniform Rules of Court, and that judgment
guides us as to if you want to be successful with urgent applications, what you need to comply with. And it sets out quite clearly what needs to be done. It explains what needs to be done. I'm not sure in the context of the Northwest Division, we have that kind of judgment. And looking at your judgment, I just want to understand from you, what is the test for agency? And what do litigants who want relief on an urgent basis need to comply with in order to fulfill what is stated in Rule 6, Sub-Rule 12, in that jurisdiction? I just want to get that understanding, because when I look at your judgment, you cite the rule and you revert back to the facts of the case, not necessarily the actual agency, and you proceed to determine that the matter is not urgent. So I just want to understand, in the context of the Northwest, I know that now you are at the Free State, but because this judgment, you were sitting in Mafikeng, I just want to understand what is the test for agency and what needs to be complied with for one to be successful when he or she has brought an urgent application.
I think the test for agency applies in all the divisions. It's not specifically for Gauteng, Northwest, or wherever. In all divisions, the test for agency applies. So in an urgent application, the first thing that the applicant must prove is agency, to prove that that matter indeed there's agency in that matter, an order must be granted as soon as possible, as there might be some injury that the applicant might find himself or herself in. So there's no specific test for a specific division.
No, that's not the proposition that I'm putting to you. Uniform rules of court applies to the High Court and therefore to all the divisions of the High Court. That I'm fine with it. But each and every division, there will be a certain approach or a certain attitude to certain applications because of the frequency with which those kinds of applications are brought and how perhaps the practitioners in that division treat those kind of applications. So I know that when I bring an urgent application in Gauteng, there is a case, East Rock Trading, that outlines what I need to do. And when I do exactly that, I know I'll be fine. But when I look at your judgment, it doesn't deal with Rule 6.12. It just set it out, but it doesn't really deal with it for one to understand in the context of that case whether the matter was urgent or not, and if it was not urgent, why that matter was not urgent. As I was asking you about the test for agency.
I'm not aware of any special test for agency in the Northwest Province.
Okay, no, it's fine. I will leave it there. Thank you very much.
Rudolph?
Thank you very much, Acting CJ. Advocate Mahlangu, I can see that this time around you are better than last time. Your composure, your demeanor is much better. And I remember you were unsettled by the question that Advocate Nkaitobi asked you. I wish that this time around he asked you again a question. I want to see how will you behave.
Thank you for that, Commissioner.
Yes, now.
But I hope Commissioner Nkaitobi doesn't unsettle me.
I want to ask you about the case of 2001, and I want to test your understanding.
Is it one of my cases, Commissioner?
No, it's not your case.
Okay.
It is the Lubaka case that deals with Section 174 of the Criminal Procedures Act, where an accused is discharged at the end of the state case. And my take is around the issue of presumption. And there's been a lot of discussion in the public domain about that case and whether the provision of Section 174 is it still relevant or not? And I want to get your understanding. In your view, do you think that that provision must be abolished or not? And what is your take on that?
You mean the 174, section 174 should be
174, yeah.
abolished? I don't think that it should be abolished. I think the accused persons have the constitutional rights in court as much as the state that is presenting the case, because it will be a fruitless exercise if the judge or the presiding officer presides on the matter where he could see, or he or she could see that the accused person, there's no prima facie case against the accused person. So once that application is brought, I think it's up to the accused to bring it or not, because it's not a meritorious thing that the court
But
can
with my
decide on.
limited legal knowledge and understanding, that provision gives a presiding officer or a judge a discretion, and don't you think that that is problematic in that respect?
No, I don't think that is problematic. Like I said, the accused person has a right. If once I can see that the state could not prove his case beyond reasonable doubt, then the accused person can bring that application. And as you have rightly said, that is the discretion of the court whether to grant it or not.
All right, thank you very much. Thank you.
Follow up, CJ. Ms. Matlango, I just want to understand. Are you saying that the test for 174 discharge, at that stage, the state has to prove its case beyond a reasonable doubt? Is that your submission?
My submission is that there's no prima facie case against the accused
Yes.
person, yes.
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 Thank you very much, DCJ. Good afternoon, Ms. Mahlangu.
Good afternoon, JP.
My question relates to what you've listed in paragraph 9.6 of your questionnaire.
Let me go to it, JP.
I'm on the electronic version, so I don't know what the page number is on the physical version. But the question relates to the 9 part-head matters that you've reflected there, and it sort of worried me. I've never come across a judge having more than 1, probably 2 part-head matters. I know this is norm in the regional court. Are these high court matters?
Yes, JP, there were high court matters. If I may just a little
Yes.
tell how did it come that I have those part-head matters. Those part-head matters, most of them, if I think 1 or 2 were in the High Court Mafikeng, they were in the circuit courts. And in the circuit courts, there's no backup once this load shedding. At some stage, we had 4-hour load shedding, and you start a trial. Unfortunately, you cannot be able to finalize it. It becomes better if load shedding starts at 12, at least you can start the court at 8 and try to push as much as you can so that you can finalize those matters. But unfortunately, the predicament I found myself in the circuit courts, there's nothing much that you can do. Like, for example, at Garankuwa Circuit Court, there's a generator, but the generator doesn't operate the recording machines. At Rexdorp, there's no generator. Once it is load shedding, the court becomes so dark that everyone leaves the building. So unfortunately, because of that, JP, I couldn't. If you can see those, I've started to act in 2020, but most of those part heads are 2022 when load shedding started to be severe in the country.
Okay. Thank you very much for that, because I was really worried. I remain worried because the High Courts run a running roll system, which is intended to make sure you don't take new work when you still have old work unfinished, isn't it?
Yes, like I said, it's circuit courts, and circuit court is beyond our control.
Yeah.
It's
But
something
are they
else.
still all outstanding, the 9?
No, JP. I managed to finalize 4. It's only 5 now that are still outstanding.
Okay, last question, DCJ. The 2 reserve judgments you mentioned there, that were reserved in October last year, were they handed down?
They were handed down, yes, JP.
When?
We closed, I think, around November. Yes,
Okay.
yes,
Around November?
yes. We
But
closed-
when did you file your application? Didn't you file it in November?
Yes, I think 2 weeks after I filed JP, because one of them was a full court judgment. Yes.
Thank you, DCJ.
DM?
No, just as a follow-up to JP Mlambo, he asked you, sorry, good afternoon. He asked you about the 9 part herds, and you blamed the circuit courts. But of the 9, 5 of them are Mafeking.
Good afternoon, Commissioner. Yes, I said yes, earlier that most of them are in the circuit courts.
No, with respect, 5 out of 9 is the majority, that is Mafeking.
Those are the ones that are managed to finalize, yes.
I'm sorry, I'm not getting you.
Yes, I said.
5 out of 9 are from Mafeking. You complained about Garankuwa, that's 1. And then you complained about Klerksdorp, which is 3. So most are from Mafeking, but you're saying the problem is the circuit courts. But what's the problem with Mafeking where there is a generator?
Commissioner, if I may say, the Northwest Division, the role is not like the Gauteng one, wherein you have a running trial for 2 weeks or 3 weeks. So the ones that we do also pick up part heads in Mafeking because of that's how the role is structured. So I did have the part heads also in Mafeking that I postponed, then that I managed also to finalize.
Okay, so you're saying what you said to Judge JP Mlambo is incorrect?
No, it's not incorrect. I said most of them are in the circuit courts. And
Most
that's
of them are in Mafeking. Anyway, I'll drop it. Thank you.
Yes.
Any further questions for this candidate, colleagues? Oh, sorry, I forgot you, Prof. Advocate Steinbeck. It's late.
Good afternoon, Ms. Mhlangu.
Good afternoon, Commissioner.
Just to disclose, we were shared chambers some time ago, so we know each other from practice.
Yes.
I noticed that in the GCB's review, they talk about a judgment, Telapedi versus Lawu, a defamation action.
Yes, yes.
And unfortunately, I couldn't find it online. But what I read from what the GCB has said is that you granted absolution from the instance. The defendant had, in his plea, had admitted that he had made the statement on TV. So I want to understand, firstly, do you still stand by that judgment? And on what basis did you make that finding?
Yes, if I may, just as I've said earlier, I even referred to the matter of EFF versus Trevor Manuel.
Yeah.
In this matter, the plaintiff says the defendant uttered this weight, and the defendant, according to the plaintiff, she assumed that she was referring to her. And then in court, there was a clip, the TV clip that was brought in court. The defendant said in that clip, wearing the Nehau uniform, having placards in front of the building of the municipality, or wherever building, I just forgot which building was that. And then the defendant uttered the words and says, I'm here on behalf of Nehau. I'm going to speak on behalf of Nehau as a chairperson. And the plaintiff during the trial considered that, yes, that's what the defendant said. The defendant said he was speaking on behalf of Nehau. So then the defendant could not be held liable for what was said on behalf of Nehau and not on his personal capacity. And then what I was opinion of Commissioner was that the defendants on that day having placards, they could not have simultaneously spoken to that TV journalist. That is why the chairperson was allowed to speak on their behalf.
Now, I did hear you say that earlier, but I wanted to understand that. My understanding of the law of defamation is that if the plaintiff establishes that the defamatory words were published and were about him or her, then the plaintiff has established defamation.
Yeah,
and then the onus shifts.
Yes, if I may go further, is in that television clip, the name of the plaintiff was not uttered. The defendant was generalizing, saying the employees of this department, all of them gave themselves the increment of 51%, and therefore they should all be suspended pending the investigation. And the plaintiff in court considered that, yes, I only became aware that my salary was increased after I saw that television clip. I was not aware that my salary was increased, and I made arrangement to prepay whatever was paid to me. So the name of the plaintiff was not mentioned. That is why I said I referred to this matter, wherein the name of the person was mentioned in TV, on television, that such and such a person did 1, 2, 3. So in this matter, the plaintiff's name was never uttered.
But we know that a plaintiff's name doesn't need to be mentioned for the plaintiff to be identifiable. So can you tell me the reasons you gave in your judgment for granting absolution? You don't recall?
I can recall, yes.
Okay, then I'll leave it at that.
Could I make just a short follow-up, not to Commissioner Steinberg, but to Commissioner Marumo Achai? I'm not asking you a question this time, Judge. I'm just trying to help you to make sure you've answered the question that's already been asked. Rule 612B, you remember the question you were asked about agency?
Yes.
Contains 2 requirements for agency. You were asked to explain, I think the word that was used is the test, but let me just try to simplify because I'm sure you know the answer. What are the 2 requirements for agency under Rule 612B?
The applicant must prove that the matter is urgent.
But the point is, what should the applicant say to prove the matter is urgent?
I can't think of it on my feet now, Commissioner.
Thank you, TCJ.
Other questions from the virtual platform?
Maybe just one, DCJ.
Yes, Commissioner Bernard.
Thank you. Good afternoon, Advocate Mslangu. When should a judge recuse herself from hearing in a matter?
Good afternoon, Commissioner. The main test for recusal is biasness. Once the judge became biased to the matter, for example, the judge becomes interested in the matter or in the judgment, or maybe the judge is familiar with the facts, for example, knows one of the parties, then the judge must recuse himself from the matter.
Thank you very much. Thank you, DCJ.
Yes, Commissioner Bernard. AP person.
Thank you, DCJ. Advocate Mahlango, I want to take you to paragraph 6.3 of the feedback from the GCB. Which states that the concerns that were noted during your October 2022 interview still persist.
6 point what, come again, Chair?
6.3.
3. Oh, yes, yes.
Do you have a response to
that? Yes, JP, I can see. When I think this matter was relating to quantum, as you can see in paragraph 1, 2, 3, 4, 5. They say the candidate is criticized for not considering constitutional rights of plaintiff in unlawful arrest matters that have said before her when assessing appropriate award. In quantum matters, I normally do not deal with the constitutional rights. I deal with them in a merit. In quantum, I cite the previous cases wherein the awards are dealt with, and then I base the award that I'm giving to the particular plaintiff based on the previous cases that I'm going through. But I don't think that this concern is not correct. I cannot repeat what I was told I was not doing in the previous interviews, Commissioner.
Thank you. Then we proceed next to paragraph 6.4. Where an application was moved before you for substituted service, which you granted.
JP, thank you again for this question. I went through paragraph 6.4, but unfortunately, because there are not enough facts here of how did this happen, I couldn't think of the case that I did relating to this. If I can say this, JP, that I've done many unopposed matters in the Northwest, and I really do not remember making such a mistake. But indeed, if indeed I did this mistake, I would expect the practitioner to can bring it to my attention to make a rescission so that this order can be rescinded. But I cannot, I don't think, I cannot remember which matter is this. I've done more than, I think, 1,000 unopposed matters in my stay in the Northwest Province.
But what I find troublesome is the fact that you granted an order for substituted service, and immediately thereafter, the legal representative for the plaintiff seeks default judgment, which you grant, telling you that we have already served this summons by SMS. So in effect, you granted default judgment even before there was service of the process on the defendant, shutting the door of the court to the defendant.
Yes, as I've said, Commissioner, that I cannot remember this matter, so therefore I can't say what happened on this matter exactly.
Did you take the trouble to investigate?
Unfortunately, also there's no case number. I didn't know how to approach it. If maybe there was a case number, I could have maybe seek the record or something to check what happened on this day. But I'm very thorough in my unopposed matters. I don't believe that I can make such a mistake, but should it be brought in my attention, I will.
Did it not occur to you, your counsel yourself, to approach the GCB? Could you please provide me with details of this matter so that I can prepare for the upcoming interview in April and be in a position to deal with what you have raised in that paragraph?
Okay. I did not think of doing that, Commissioner.
Thank you. Thank you, DCJ.
Commissioner Matolo Lepu.
Thank you, Deputy Chief Justice. Good afternoon.
Good afternoon, Commissioner.
You know, I'm looking at the comments from the Law Society of South Africa. I just wanted to confirm, especially on the last paragraph. Do you have the
Yes, I have it, Commissioner.
I mean, the comment says, due to the
the issues that were raised in October 2022 by several commissioners, it appears that the applicant needs to gain more experience in civil litigation to overcome the shortcomings, and as such, they're not supporting you. But do you think that's fair?
I
Or-
don't think that is fair, Commissioner. I'm of a view that I have enough civil experience. And like, if I can mention that my practice was civil litigation. My practice was trial court. So, and also most of my judgments are, in fact, not all, yeah, most of my judgments are civil trials. So I don't, this comment is very defective, Commissioner.
Okay, thank you.
The title of the head of court of the Supreme Court of Appeal is president. A person who acts in that position is acting president, not JP. So
Oh, yes.
Commissioner Betze next to me is acting president Betze, not JP Betze.
Oh, my apologies to President Betze. Yes. I
All
hope
right.
my apology is going to be accepted.
Yeah.
Yes.
Well, we have finished interviewing you, Ms. Mahlangu. Thank you so much for taking the time to come here and subjecting yourself to all these questions.
Yeah, thank you.
Your torture is over.
Thank you. Thank you very much, everyone, for giving me time to be interviewed again.
You're excused.
Thank you.
Good afternoon, Ms. Mfanyana.
Good afternoon, DCJ.
I'm sorry, are you ready?
Yes, I am ready, DCJ. Thank you.
All right. I hope you are well.
I am well. Thank you, DCJ. You, I hope you are also well.
Yes, I am, thank you. And welcome back. I'm glad you came back. I must say that at the outset.
Thank you, DCJ. Yeah, here we are.
Yeah, let's see what happens this time. You hold a number of academic qualifications.
Yes, DCJ, to be exact, 3 degrees and
Yeah,
3
and the number of postgrad certificates.
Post-graduation certificates. Yes.
What are these postgrad certificates?
The first one is a certificate on legal aspects of e-commerce. I think that was the time when electronic commerce was starting out, signing of contracts electronically and the like. And the next one would be a certificate in energy law and a certificate in aviation, space and telecommunications law.
Yeah. All very niche. You are an attorney by profession, having started at the Legal Aid Board many years ago, in 1997, right?
Indeed, DCJ.
And you worked your way through to your own office today, your own practice.
That's correct.
Which you
DCJ.
started in 2009.
That is so, yes, DCJ.
But you did a few things in between, that is between 2009 and obtaining your articles. Can you tell us briefly where I see you've been with the Human Rights Commission and other bodies as well? Just briefly.
Indeed, DCJ, trying to find one's feet. So I did my articles with the Legal Aid Board, as it was then called. When I qualified, I then stayed on for just over a year as a fully fledged attorney, professional assistant, as we called them those days. From there, I went to the Human Rights Commission as a legal officer or legal advisor, if you like. And thereafter, I had a short stint with an NGO called the Center of Study of Violence and Reconciliation. And as I was a research fellow there, just honing in my research skills. Thereafter, I worked for the Law Society of the Northern Provinces, the current LPC. I might just, maybe mention, while working at the Law Society, I was doing investigating my own colleagues. Not a very popular job or position, but I found a way to make it work for me and for my colleagues, particularly the previously disadvantaged, because I then tried to make it, practical and sort of give a face to the Law Society, that the Law Society is not the scary body, but if you comply, you will not have to fear the Law Society. That taught me also a lot of discipline moving forward to my own practice, that when it comes to trust accounts, that is not a place where you want to play it. As a matter of fact, I think one of my former colleagues was my boss at the time, Johan van Staden, said to me, "We can see that you've opened your own practice. We will never see you in the disciplinary committee on the other side of the table." From the Law Society, I then moved to work for the National Intelligence Agency, where I worked as an investigator, once again, investigating my own colleagues, because I was in the internal investigation unit. So it was also matters of conduct, discipline, and all of those. And just to move a step back to the Human Rights Commission, that I think quite early on in my career gave me a grasp of the society that we live in, what people out there face, what can and cannot be done to advance our society. I apologize, I am jumping around
No.
as these effects come to me. And back to the investigation unit of the NIA, I then moved on as a promotional move to the Office of the Inspector General for Intelligence, which was it still is the body that oversees the intelligence structures. There I worked as a compliance, or what we call a review officer, until I left in 2007, in 2009, I'm sorry, and started opened my own firm, hit the ground running.
Yeah, that's quite an interesting career. What kind of practice do you run? What kind of work lands on your desk?
Deputy Chief Justice, it's a generalist practice.
Just a moment. Is that yours, Commissioner Nyambi? What's going on over there?
I'm sorry, CJ.
Carry on, Ms. Fenyani.
It's a generalist practice, DCJ. I do just about everything I can lay my hands on that I think I am capable of doing, or I have the staff to assist me in. It didn't, when it started though, I did do criminal matters as well. It has changed complexion as one gets more and more experience. I started off doing everything, including some criminal matters. Reason for this is that I was exposed to criminal matters quite early on in my career. If you recall, I don't know if you recall, those days the legal aid was doing predominantly criminal work and a bit of civil work and labor work. So applicants had to put up a really good case why their labor matters should be taken, not so much for civil matters, but criminal matters. We assisted applicants as a matter of course. Then I carried that on into my practice, and I quite almost immediately positioned myself to do contract work. The reason for this was that commercial work was not, something that was easy to get. But I figured that if I am going to place myself in a position where I can do contracts, I will at the same time be able to sort of get an idea into the inner workings of whichever client I am servicing at the time. So if I have 3 clients, one in engineering, one in aviation, and one in education, inevitably I do gain a little bit of information into the aspects of their work while I'm reviewing the contract or vetting it or drafting the contract. And that then filtered through to me drafting more focused contracts for my specific clients, clients in aviation, clients in financial institutions, clients in, energy. I didn't get that much work. I mean, we know the briefing pattern story. But you push hard and get whatever you get. Do it to the best of your ability. And so those were the matters that I did. And I also put my experience in intelligence to work, and my experience at the Law Society to work by starting at a very small scale to do investigations, because it was something that I was quite familiar with. And to this day, my practice does some of the commercial work that we are able to do, but not to its fullest. I mean, commercial work is vast in the disciplines that I've mentioned, and a bit of administrative law, which is a topic I like quite, but that I am not very knowledgeable in. And that.
And labor law as well.
Labor law, yes, not so much. Labor law kind of follows on the instructions that you would get. For example, if you have an administrative law issue review, for example, in most instances it would involve, if you're talking about an exercise of improper exercise of power, for example, by maybe a state organ, you're going to likely find a dismissal there, and you find yourself being instructed in these labor matters as well. So I've gotten a limited exposure in labor matters as well.
All right. You've acted in the High Court since 2018, right?
Indeed, DCJ.
And you count a total of about 44 weeks experience on the High Court bench.
Yes, at the time, I think at the time that I was completing the application form, I've added a few more weeks.
How many?
I've added about 17 weeks. I'm on week 17 now.
Oh, you're acting at the moment?
I am acting at the
Where?
moment in the Northwest decision.
All right. All right. You have written judgments, of course, during your acting stints.
Indeed, I have.
And how many would you say you've penned so far?
When I last counted, I must be honest, coming here today, I didn't, have a sort of an updated count, but a few.
Just an estimate?
Estimated about 87.
And some have been taken on appeal.
Indeed.
And you're overturned.
And confirmed.
But yeah, it's been a mixed bunch.
It has been.
All right. Do you have any reserve judgments that are older than 3 months now?
Regrettably, Chief DCJ, I do have 2 that are older than 3 months, that are just over 4 months.
What has delayed the delivery of those judgments, if I may ask?
Well, without sounding defensive, I think perhaps my record can bear me out on this. I generally endeavor to deliver all my judgments in time, sometimes as quickly as within days, depending on the urgency and the aspects involved. But with these judgments, they are a bit complex. And I had to make an election of whether I rushed through this judgment and without a full or thorough research. So that is mainly that's the main reason that they involve a number of complex issues, not just one complex issue, but a number of complex issues. Competing with that is the amount of work that the Northwest Division has. I think I myself going there underestimated it. You look at a small division and you say, this is a small division of accidents in bigger divisions. I'm going to go there, I'm going to show them. And when you get there, you become quite surprised. So with the amount or the number of judges, there are very few judges there, you sort of have a responsibility to play together with your brothers and sisters and assist without making excuses on doing the work. So that has affected the delivery of the judgments. But if it is any consolation, I don't know, to myself or to you, DCJ, at the time that I completed my application form, I had listed about 8 judgments that were reserved at the time. But that was in my first month in the Northwest Division, but I have since delivered 6 of those, and these 2 are from that list. It's only those 2 from that list.
Okay.
Yes.
When do you expect to deliver them?
I have been working out a sort of a strategy, because it requires a strategy on how I am going to do this, and I've resolved that maybe working extra long hours on weekends specifically. I must say that it also was my intention to handle them during recess, but what happened then during recess is that I then sat down 2 of my part head matters. I had 3 part head matters at the time I completed the form. So I sat down, as a matter of course, I sat down my part head matters during recess. So I spent my recess time attending to the part head matters, or at least one of the part head matters. But I intend to deliver them. I wouldn't want to give a specific time, but as speedily as possible. But if my plan comes to fruition, maybe in a space of 2 weeks, I think that's a fairly reasonable estimate.
Thank you, Ms. Fenyan. I'll hand over to the other commissioners to put questions to you, starting with Judge President Hendricks.
Thank you,
DCJ. Good afternoon, Ms. Mfanyana.
Good afternoon, JP.
Yeah. Can I start by asking you a question? The post that you're applying for is for a judge in the Northwest Division.
Indeed, it is.
Yeah, because the Society of Law Teachers of Southern Africa states, she is therefore most, and I quote, she is therefore most suitable to be considered for appointment as the Deputy Judge President of the Northwest Division of the High Court, unquote. Now that position is filled. We went through the interviews in October.
Well, not according to the law teachers, JP.
Yeah.
I think.
No, just to set the record straight.
Thank you.
Yeah. Now that, can I just refer you also to another comment, this time by the Black Lawyers Association, BLA. In paragraph 4.2.4, it is stated, and I quote, Ms. Mfanyana has several part-head matters which are set down for a hearing soon.
Yes.
Yes. Can you comment on that, please?
JP, I did see this, but my form would bear me out, which I think it's their source for any comment that they could make. I took that to be nothing other than just an error on their part. At the time I completed the form, as I've already stated, I had 3 partly heard matters, and 1 has been finalized, and it's 2 that I handled during recess, but they remain part-heard matters, but they have progressed somewhat.
Yes. Thank you. And then during the week of the 1st of December last year, I was on circuit court in Garankuwa. And then there was an incident where your colleague was to do the unopposed motion on the Thursday. There were 89 matters on the roll, and your colleague approached you on the Wednesday evening, on the virtually the eve of the motion court day. And then you had to step in. Perhaps you can enlighten the commissioners, what was your role?
So what had happened is that my colleague, who was also an acting judge, a fairly new acting judge at that, approached me the evening before the motion court day, and just for pointers on how, because he was in court that day, almost the whole of the Wednesday, and you wanted to know, does he stay in chambers or does he take the files to the hotel and whatnot? And I gave him my opinion. But then later on that night, he then told me that he wasn't feeling well. And I said what I said to him and left it at that. And we were staying at the same hotel as well. In the early hours of the morning, I received a message on my phone with an indication that he was in hospital. And it was in the wee hours of the morning. I tried to call him, and he did not respond. So I waited until it was reasonable hours, at about 6 o'clock, knowing that the judge president was not was on circuit. I then phoned the deputy judge president, my sister Judge, and I tried to find out whether the said judge had contacted her, because it seemed to me that there might be a problem, being aware that he would have been was doing motion court that day, and being aware how many matters were on the roll. To fast forward then, JP, the deputy judge president was not aware, but that then prompted her to rush to court, and we met at court, just trying to find a way to assist. And we sort of requested the parties just to give us a few more hours than usual, just an indulgence to not start court when court should start, so that we could be given an opportunity to peruse the files and resolve whatever sticky issues there may be, and start court, so that we could attend to the matters and the parties. I just thought that it would be a travesty of justice to send so many counsel away because matters could not be attended to, but with the assistance of everybody, I must say, who was able to take on my role while I was taking care of my brother's role, together with the DJP. Everybody came together and we assisted each other, and we did motion court, and the matters were done, and the role was disposed of, I think, without much problem.
There were 89 matters on the roll.
81.
81 matters on the
Yes,
roll.
there were 81.
And you started with a motion court.
Yes, I started
And
with-
doing half of it, that is what I was told by the DCJ.
Yes.
And
we
then
did 41
she
motion.
continued.
Yes.
Yes. There are some of your matters that were taken on appeal. This is a follow-up question already asked by the DCJ. How many matters were upheld and how many matters were overturned on appeal?
It was 11 matters, and I was confirmed on 6 of the matters and overturned on 5.
Yes. Thank you. DCJ, I don't have any further questions.
Thank you, JP.
Thank you.
Premier, it's your turn.
I supposed that your acting stints constitute a key consideration in your appointment as a judge, as a layperson, I suppose so.
I also suppose so, Premier.
I want to refer you to your exchanges with Commissioner Notes. Do you recall those? They are in the transcripts.
Commissioner?
Notes. Well, let me assist you. He said, if there are 11 applications for leave to appeal against your judgment, and you do not know anything about them, how does that impact on the accountability?
Oh, okay. Yes, I remember that, Premier. That was Commissioner Nokesi. Yes. Sorry, Commissioner. That was Commissioner Nokesi, and I remember very well the onset of that question. That question was a follow-on from a question that had been asked by Commissioner Nyambi about my understanding of judicial accountability. Having explained judicial accountability the way that I understand it, Commissioner Nokesi then followed up to ask about basically my explanation of judicial accountability. Now I don't know anything about these 11 matters, because the question also, another question was, I wouldn't have any idea. That was from the judge president of the Eastern Cape, as I was applying in the Eastern Cape at the time, because I did not know what could have happened to those matters. Yes, then my response to that, I still remember as well, was that my understanding of it is that that would be an administrative function that would take place and filter through from the administrators through perhaps to the judges. I think perhaps even to the judge president, because once a matter is out, once a matter has been appealed against to a higher court, then that matter is out of your hands. You don't exercise any control over that matter as the court a quo. Say, for example, if you have to, follow up and find out where is the matter, is it going to be heard, when is it going to be heard? So it was in respect of that question was asked.
But I don't think it was the intention of his inquiry. He was just amazed, Nokesi, that you were not aware as to what happened to the judgment. And so you reverted to the explanation about accountability, and you did not really respond to his question. But that's all right. The question I'm keen to get your response to is, in the Northwest, how are you going to contribute towards the promotion and advancement of women in the judiciary? Thank you.
Premier, if I may just respond to the previous question, the previous comment with regards to judicial accountability. I think that I did try to answer the question to the best of my ability that was asked by Mr. Nokesi, because it was indeed attached to the question of accountability. Because his question was, how does that play out with the accountability that you've just explained? I'm paraphrasing, that you don't know where it is. In other words, is that accountability? Are you accountable? So that is how I understood the question, and I answered it. Coming to the last question that you asked, Premier, the issue of women, being a woman myself, is something that comes naturally to me. How have I demonstrated this? I am a member of the South African Women Lawyers Association. And I am not just a member of the South African Women Lawyers Association. I'm a member who's actively involved in the advancement of women within the organization. How do I do this? We are women of different ages, women of different understandings and backgrounds and all of that. When we come together as a woman organization in Saula, we do all we can, all in our power, to uplift the other women. We even have a slogan for one of our projects that says, "Lift as you rise." So the intention of that is to take the younger professionals with us. So I have on my radar a number of women. I must also just include, and a few young men as well, that some I mentor, some I just give ad hoc advice, just to be accessible to them, to say, let's do this. I will try and share the little that I know. Whatever you can use, try and use that, but also know that I am accessible, I'm available. I will continue with that. And I have already had discussions with Deputy Judge President Jaji, whom I also found is doing this at a very much more organized scale in the Northwest, going to universities and having, doing mock trials in court and having these young people come to her chambers. I've met 2 of them already, and that's how I intend to advance women at the professional level. Thank you, Premier.
Any questions, Commissioners? Prof?
Thank you very much, DCJ. Good afternoon.
Good afternoon, Commissioner Marumachaya.
Thank you very much. I see that you, and I must say that I enjoyed reading 2 of your judgments.
Thank you, Commissioner.
The first one is PM versus MSM, and the second one is DS versus GS. They dealt with Rule 43, interim maintenance and contribution to costs.
Yes.
I'm not sure you remember those judgments.
I think if you go a little bit into the facts of it,
Okay.
I will remember, but with the initials that
Okay.
we
No,
use.
let me be fair to you, because this is not a test, so it's not about you memorizing. So I will not go into the facts, but I'm just going to put general propositions to you. Because I do agree with your approach in both judgments, but I just want to give you a general proposition. Because on one judgment you dismiss contribution to costs, and on the other one you granted it, and I think correctly so in both judgments. I just want to ask you this question. On the understanding that when people are married in community of property, they are the joint owners in undivided shares of their joint estate or the assets that are held in the joint estate, on that understanding. And you find that you have parties before you where one of the parties has the keys to the joint estate and the other one does not have the keys to the joint estate. And these parties have to litigate at the same level. Do you think that the current test that is used to determine whether or not the financially weaker spouse in the marriage is entitled to contribution to costs is sustainable, or is it fair or equitable, if you like? I'm not sure, did you get the question?
Yes, I'm just mulling over it. I'm just mulling over it. I did, Commissioner. So the idea is to ensure that the party without means, or the spouse that does not have means, is brought to par with the party that has got a means, so that they do not litigate at different scales. Does that give you an indication that I've understood the question, Commissioner?
No, it does. I just want to hear how it flows.
All right. Right. So that is where then the issue of a contribution to costs will come in. That parties, particularly the female spouse, as it has historically been, would be left destitute and not be able to litigate at the same scale as her husband would be litigating. So therefore, the fact that they are married in community of property, and the fact that they each other owe each other a duty of care should come into play. And therefore, the law as it stands then recognizes that that spouse should at least get, some kind of assistance. There are, of course, riders to it, issues to be considered, like if you litigate at an exorbitant scale, then the law can't meet that. Whether that is fair and should remain the way that it is, I think it's debatable. The debate for me would come from the fact that oftentimes in Rule 43 applications, the court is not privy to all the information there is in respect of the means of the parties. And based only on the financial disclosures, not only, I apologize, partly on the financial disclosures, the papers, before the court, then the court has to make a determination on the basis of that information, only to find that the other party has got, access to sometimes non-traditional means of earning, an income. So I do think that there's a case to be made for maybe an inquiry to be infused into the test or the determination.
No, I accept that, and I think that's what Rule 43 seeks to do, and that's how, by and large, the judges are actually applying it. But I'm asking a broader question, that is the test that is currently being used an adequate test, in that the person who is a co-owner in undivided shares of the assets held in the joint estate, the one with the keys, is able to litigate at the extent to which that person wants to. But the other party, who is a financially weaker spouse, has to show that they don't have the means, but they are the co-owners. I'm not sure if you understand what I'm getting at. You are the co-owner of these assets, but the court are requiring you, based on this rule, to show that you don't have the means, but you are the owner of the means.
I hear you, but then you just don't have the key to the means. So in other words, you're suggesting that the court, perhaps to simplify it, should say to the one who has the keys, give the other person the keys. Let's share this for the parties to share, because they are indeed joint owners. I think there's a case to be made at the Commissioner that it doesn't seem to be fair, you know, as you are putting it.
No, definitely. Thank you very much, DCJ.
Commissioner
Thank you.
Moimang, sorry, my mic was not on.
Thank you, DCJ. Good afternoon, Acting Judge Fanyana.
Good afternoon, Commissioner Moima.
Just one question from my side, which relates to your application, page 2, under 6, your employment background. You did allude to the work that you have done in the past. I just want to check as to whether the under 5 and 6, which you were working at from 2002 up to 2009, how did it shape and prepare you for the opening of your legal practice, and does it continue to shape your work in your aspiration to be a part of the judiciary of South Africa? Thank you.
Thank you, Commissioner. Just to confirm, I think you said page 2.
Yes, it's page 2 of your CV.
Of the CV.
Yes. And
Yes.
number 6, the chronological particulars of your employment history. That's
Yes.
where I am, yes.
And number 5, you said.
5 and 6.
Indeed, all of these have come in handy, and they have shaped me and assisted me and continue to assist me in my discharging of my judicial duties. How so? The BUris LLB, LLM, those are standard legal qualifications. So it goes without saying that they have, assisted me. What I could just single out from those qualifications is that in my LLM degree, even though it was a general coursework, I focused on mercantile law, we called it then the current commercial law, and took an elective on advanced human rights law. So just to talk on those two briefly, it then turns out that the human rights would be at the core of what every judicial officer has to do on a daily basis. Because there isn't a single day that a judge can go to court and not have a picture of the Constitution in front of, well, even, imaginatively. The other qualifications in energy law, I must confess with energy law.
Maybe just to redirect you, my apology, DCJ. I'm more at the employment history after your qualifications.
Right.
Your work at the National Intelligence Agency and the Office of the IGI. That's why I am.
Oh, not all of them.
No, I'm only on this 5 and 6.
Only on 5 and 6.
Yes, and I understand you understand where I come from.
Yes, Commissioner. Commissioner, I come from the school of thought that all learning is crucial. If we zoom into the duties and the kind of work without divulging much, I am fully equipped in investigations. When I sit and look at my papers, I try and do that as thoroughly as I can, that is, in understanding the factual matrix of the issue before me. And that I can only, or to a large extent, credit it to this training. Being in an oversight position at the OIGI, I then use that knowledge when I adjudicate my matters, to ensure that I understand all the submissions that are made by counsel before me. So I give counsel a fair opportunity to address me, because the nature of the work that I did is such that you don't jump into situations. You observe, sometimes observe quietly, sometimes unseen, but in the circumstances of a judicial officer, I am always seen. But the most important thing is that you see people and that the people who appear before you feel that they are seen and heard.
Thank you, DCJ.
Thank you, Commissioner. Commissioner Baloyi.
Thank you, DCJ. Good afternoon, Mr. Fenyane.
Good afternoon, Commissioner Baloyi.
Yes. Mr. Fenyane, I would like us to look at your judgment, the Makana something league. You remember that case?
Yes, I
that judgment.
Yes, I do, Commissioner Baloyi.
Yes, we have it in your bundle of documents. It's Makana Unity League, and it's page 32 at the bottom, handwritten 32. Now, maybe firstly, when you respond, I would like to know whether when you submitted it, this judgment now, firstly, I assume you had occasion to read it again, to refresh, and whether you picked up anything that you may want to comment about. And you can do that if you want to. Now, my concern about this judgment is that you issue orders, you conclude with orders that are not supported by any of the reasons that you give in the body of the judgment or anything that is discussed in the body of the judgment. And I'll ask you, because I've tried to understand how it would come about that you do that. Now, if we could just start with, in paragraph 1, for example, of that judgment, you set out what the applicant seeks. And I'm in particular interested in prayer 4, which is about costs. Are you there with me?
paragraph 1.
Prayer 4, yeah, paragraph 1 and prayer numeral 4. It is ordered by, this is the Pickering J order. Do you see where I am?
Yes, I do see.
So in fact, it's not even prayer, it's order 4. It's that
it's an
order
order.
number 4.
Yes.
It's about costs. And then you cite what he has done there. And then the only other discussion, in fact, this is not a discussion, this is you repeating what Pickering ordered.
This is the order.
Yes, and then paragraphs later, and I think this is in paragraph 31, in fact. In paragraph 31, you discuss costs, and then you say there that the applicant, in their replying affidavit, they seek that the certain respondents must pay costs in their personal capacity, right? And you say why you are not going to order that, you don't order that. But then, in your final order, you order costs on an attorney and client scale against the respondent. Nothing in the judgment discusses that. Nowhere do you say this is what you sought, and the reason I think it's appropriate is this. You don't discuss it at all. It appears for the first time in the order. But that's not the only thing. In that same order, and if you go to the order, your order finally, this is at page 45. There are an additional 2 things that are not the product of anything that you discuss in the body of the judgment.
Paragraph?
If you're at page 45,
Yes.
and then look at, this is the paragraph, page 45, and then paragraph numbered 31, and then in C, order C, you say the second and third respondents are sentenced to 6 months imprisonment, wholly suspended on condition that the respondents comply with paragraph B. There are 2 issues about this. The one is there is no discussion where you have considered the appropriate sentence. It appears suddenly, unless I have missed it. Suddenly you're ordering 6 months and there's no explanation or reasoning why 6 months. That's one. And then 2, about that order. In fact, and maybe a more fundamental problem that I have with this is earlier on, in paragraph, if you would bear with me, in paragraph 23, you quote from a judgment about, and what it is, if you go to paragraph 23, you quote authority that where there has been non-compliance with an order, that a party later on complies, it doesn't purge or it doesn't insulate them from punishment for that period when they were not in compliance. You remember that?
Yes.
Yes.
Yes, I do.
Yes. So you have, and that's a quotation from Canton on Sea ratepayers. That's a quotation from there. So you quote and you say no more about it. And that's it. It's a standing quotation. And then you go to the order. In fact, you find that they've been in default. There was no compliance for a period. And then in your order, you say that they are held in contempt, but they must comply and they're sentenced. And that sentence will kick in only if they do not comply. So in a way, you say their compliance will insulate them. Later compliance insulates the respondents from punishment for non-compliance in an earlier period, which is contrary to what you've called this authority here. And it's not clear from the judgment, certainly, why did you quote this, to what end? And it doesn't, because it is not translating in anything in your order. That is C. So I've got a problem with how you get to C. It's not clear, order C. It's not clear in anything that you say in the judgment. And yet you've quoted authority that will allow you to hold them in contempt for that period, to punish them for that period when they were not complying. And then E, you've ordered costs in the way that you have done. Now, what bothers me about this is this a function of inattentiveness, on your part that you come out with orders that are not supported by anything that is in the body of the judgment, and you don't pick it up by the time you finish the judgment, or it's a more serious problem really of not realizing that your orders must be supported by your reasons and your discussions in the judgment. If you just explain how this comes about, in fact, these problems that I'm pointing out to you.
Yes, thank you, Commissioner Baloyi. I think the first thing that I need to mention is the judgment that I attached, and the judgment that you are referring to is a 2020 judgment. I will leave that at that. I'm not going to go further on that. And I will secondly offer this explanation again for the reason that I attached this judgment, it being a 2020 judgment. It is one of the judgments that was confirmed, in which I was confirmed by the SCA. The third explanation I would like to offer, going perhaps specifically to the issues that you raised. Perhaps if I could start with the paragraph that I think I was at, paragraph 24, where I quoted, paragraph 23, where I quoted Low J in the matter of Canton C. And you say, I say no more about it and I just leave it at that. But if you read the paragraph that follows after that, and this is perhaps my understanding, or perhaps maybe a style of writing, that paragraph that follows then talks to the principles that have been enunciated in the paragraph before by Low J. On the issue of the order that was granted, particularly paragraph C, I think it's C of the order, not what you said, if I understood you correctly, is that if you look at the quotation that I quoted, which presumably I rely on, and I think as a matter of fact, I align myself with, by suspending that term of imprisonment, I'm therefore saying that on condition they purge their contempt, then they therefore insulated from responsibility, and that is not my understanding. My understanding is that an order finding them in contempt has been made by me, and that order stands. And by suspending that order, it's my understanding of all the authorities, FACI, you can think of I can't think of the other authorities at the moment, Machabing and other authorities, is that where a court finds an applicant, or a respondent rather, to be in contempt, it is not for this court, the court that I was at the time, to say, you found in contempt, I'm punishing you now. So it does not insulate them. It's giving them an opportunity at a later stage to then come to court and give an explanation, and that is the law as I understand it in terms of those authorities. So my understanding is that it does not insulate them. The order stands there in contempt. They're given an opportunity to purge it. If they cannot give an explanation, it will stand. But if it can, then if they can give an explanation, then that contempt indeed does not stand. And I think that also resonates well with the principles of audi alteram partem, particularly in contempt proceedings, which affect the liberties of a party. On the
Yes, can I just clarify this? Just
Yes.
these two things from what you have said.
Yes, Commissioner.
You say you were confirmed by the SCA. Is that your way of saying there's nothing wrong with what I've pointed out? I've pointed out parts, the orders that I say are problematic, and I've explained why. You sentenced to 6 months, there's no explanation in the body how you get to the 6 months. If that was confirmed by the SCA, is that your way of saying there's nothing wrong with, in fact, that I'm wrong in pointing out that your 6 months sentence is not prefaced in the body of the judgment? 1, 2, your cost order, which is not discussed anyway in the body of the judgment, how you get to award attorney-client costs. If that was confirmed by the SCA, is that your way of saying there's nothing wrong? I haven't seen the confirmation by the SCA, but are you saying that my complaint about the structure and the body of this judgment is not valid? I know I've asked you a number of questions, but I'm trying to finish off so you can answer and I don't speak again. And when you say this is a 2020 judgment and you have nothing more to say, I absolutely have no idea what you mean by that.
Commissioner Baloyi, of course not. I am not saying it in defense. If you recall, when I made that statement about it being a 2020 judgment, I was explaining my reason for attaching it, first of all, and the issue that it was confirmed by the fact that it was confirmed by the SCA was the reason why I attached it. So I thought that it was something that it was one of the judgments that I would think that I could pride myself with. So it was not in respect of saying that your concerns are not valid. I apologize if it came out in that way. It really wasn't, meant to sound like that. It was simply to say this was the reason why I attached it. Yes. And hence I then gave my explanation so that my understanding, it may not be the same understanding it appears as your understanding, so we differ there. On the cost order issue, I think you referred me first to paragraph 31, where, it shows 2 paragraphs, 31, but where the party is asking for costs in personnel capacity. So my decision then to award costs on an attorney-client scale was a deviation from that, having dismissed that. So the two do not necessarily talk to each other. I dismissed the issue of cost in their personal capacities. If that, I'm not sure if I answer your question in that respect. But when it comes to the explanation for the cost order on attorney-client, which is a punitive cost order, I think I have to bow down there and take full responsibility for that. I could have explained and should have explained further why how I arrived at a decision to give them a punitive cost order.
Thank you, Mr. Fenyan. Thank you, DCJ.
Thank you, Commissioner.
Thank you, Commissioner.
Could I ask for permission to follow up?
Okay, just a point of, I'll get to you, Commissioner Nkaito, but I needed some clarity on something myself on this issue before I forget. What do you mean when you say this Makana judgment was confirmed by the SCA? Was it on appeal by way of judgment, or could it have been an application for leave that was dismissed? Because I asked because I've been searching for it, I can't find it in the website.
Oh, well, okay. My understanding is that it was upheld, DCJ. The information that I provided is information that comes from my court in Grahamstown. So if you would recall, I was asked right early on about the applications for leave to appeal, which I could not indicate whether they had been confirmed or not, or where they were. And I had since followed up with the registrar, and this is the information that this came from the chief registrar of the Eastern Cape Division. That is all the explanation I can give on that.
Okay. Commissioner Ngqaito?
Yes, I also did want to get the actual judgment that says upheld your judgment, because I also didn't find it on Safely. But I want to ask you a different question, because I think that there is a very convoluted explanation to Commissioner Baloyi's question, and I just don't want to live with the impression that you don't understand the law on contempt, because that's the impression you're creating now. So my understanding is that there is a distinction when a party is in contempt in the sense of non-compliance, as opposed to the second category of contempt of insulting the dignity of the court. But if it's contempt in the form of non-compliance, as a judge, you can do one of two things. One is you can find them guilty of contempt. And if you found them guilty of contempt, it is not as if at any future date they can come with an explanation and then you find them not guilty of contempt, if you've already found them guilty of contempt. Now, your response that says they are in contempt, but they can explain at a later stage, I don't understand what is the case that supports that, what authority, because that's not in the Auditor General versus Faki case, and of course it's not in the Zuma case. So what is the authority for that proposition?
I would have understood that it was all those authorities that I mentioned, Faki and Machabi. But my proposition was the following, that where a court finds a respondent to be in contempt of a court order, that court can make that order, provided that that respondent then purges the contempt, then they are held to be in contempt. I don't know.
No, I don't understand that. That is exactly the convolution I'm concerned about, because it seems that you are confusing the finding of contempt with the penalty for contempt. Because the question of purging contempt comes into the second stage of penalty. It has nothing to do with whether you are guilty of contempt. If you are guilty of contempt, you are guilty of contempt. There is another scenario in which a judge does not say you are guilty of contempt, but issues a rule nisi in which they say, come and show cause why you should not be found guilty of contempt. But you have not been found guilty of contempt at that stage. And it seems that those three concepts, you are not actually clear about them. And maybe that is why the judgment is as confusing as Commissioner Baloyi is pointing you to, is that you seem to confuse a scenario A, you are not guilty, but we think you may be guilty, come and show cause. Scenario B, you are guilty, but we are suspending penalty. If you come and show that you have complied, we may decide you shouldn't go to prison or you shouldn't pay a fine.
Yes.
But you are still guilty because you didn't comply.
Yes. Yes. That's how I understand it, Commissioner Ngqaitobi. And if you look at paragraph C, I'm not sure if we're understanding each other. What was then suspended was the penalty and not the contempt itself.
Well, that's precisely the point I was making, is
Yes.
that you seem to regard the penalty and the contempt as one and the same thing. But a person can be found guilty, and you can say, I think you should go to prison, but I'm
Yes.
suspending your penalty until you comply, because the remedy of a contempt serves one of two purposes. One is to ensure compliance. The other is punitive.
Yes.
In other words, regardless of whether you comply or not, we're going to send you to prison. And it just seems from the answer you've given that all of that learning from Machabeng, all of that learning from Auditor General and Faki, and all of that learning from Zuma is just conflated and confused. So I wanted to tease out these elements to just make sure that when I leave, I'm convinced that you know the law on contempt because you've applied it.
Yes, I don't think I can take it any further than that, Mr. Nkaitobi.
May I follow up? Good afternoon.
Good afternoon, Commissioner Steinberg.
Commissioner Beloy was speaking about a judgment which she found poorly reasoned. She couldn't see on the face of the judgment why you'd made certain orders. Part of your response was to say, well, you were upheld on appeal. Do you think that's an appropriate response?
Commissioner Steinberg, not in response to the flaws that are apparent from the judgment. That was not in response to that. My explanation, if I may just say it again, I was explaining my reason for including the judgment in my pack, that I considered it to be, a judgment where I was upheld by the SCA. So I considered it to be a judgment that I could pride myself with. So it was not to water down anything, any discrepancies, because from what Commissioner Beloy and Commissioner Nkaitobi are saying, they are apparent from the judgment, and that was not my understanding at the time when I wrote the judgment. But
I'm just concerned that you haven't answered Commissioner Beloy's question. You said she didn't ask you why you included it. She didn't ask you if it was upheld on appeal.
Yes.
She asked you if you agree and recognize flaws in the judgment.
Yes. Commissioner Steinberg, having been pointed to those specific flaws, I think my response, particularly to paragraphs 23, not talking to the order that was made, was to the effect that the very next paragraph, first of all, talks to that. And I then pointed her in my response to paragraph C of the order, that is what informed, what the paragraph 23 informed the order that I got. That is my reliance on the authority of Canton on Sea, of the Canton on Sea judgment. That was my response. Yes.
So final question. So you're satisfied looking back at this judgment that it is adequately reasoned in those respects?
No, Commissioner Steinberg, obviously now, if it being pointed out to me, in the lesson to be learnt when a judgment of yours is read by somebody else and they have a different understanding and they point out certain flaws to the way that you understand it, you understood it at the time that you were writing it, is that there is a case to be made there. Because it's read by a number of people. If one party can point out a flaw in it and read it in a different way, it means that many other parties, so that is not something that I can defend at all.
Commissioner Lucas?
As a follow-up, the Deputy Chief Justice just greeted on our behalf due to time. You accept that all judgments, there is no perfect judgment by nature. There is no judgment that is perfect. And secondly, from the points that are being discrepancies or shortcomings in this judgment that are pointed to you, are you prepared to say, look, I've picked up and I will learn from them and develop and move forward?
Oh, indeed, Commissioner Jesse. As a matter of fact, you may recall that first of all, I must agree with you when I say I don't write perfect judgments. I try by all I can to write, first to understand the facts of the matter and to understand the law and apply the law to the facts correctly. I try to do that. And when I go back, not having been here before, all the comments that are made, all the flaws that are pointed out, these are not things that leave me. I know as a matter of fact that even in the previous judgments that these things were pointed out, I made a point of going there. And what I do, and perhaps I could also mention, repeat the fact that I said this was a 2020 judgment. Going forward, I painstakingly look, at my judgments. And the other thing, being I think in all divisions as well, I get, a second read-through and opinion from my senior colleagues as well on the judgment. So this being one of those judgments that was written way back then, I don't think that this is something that I should, continue, being guilty of as time goes on. Otherwise,
thank you.
I would not let.
Thank you, TCJ.
Any further questions, colleagues? Colleagues on the virtual platform?
Thank you, DCJ. Just one. Ms. Mfanyana, when should a judge recuse herself from hearing a matter?
I think when there's a conflict of interest, by saying when the judge is conflicted, may be simply a matter of perception. And I would, proffer that even a perception, like perceived conflict, is sufficient for a judge to recuse themselves.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Banat. And there are no further questions for you, Ms. Peñana. So we've reached the end of your interview. You are excused.
Thank you very much.
Thank you for your time.
Thank you for yours, DCJ, and thank you to the commissioners as well.